Hello, everybody. I think, hopefully, maybe, potentially. Let's see. Potentially. Okay, it should be good. You guys hear me okay? Hey, Aaron. I hope you guys can hear me. Okay, cool. Yeah, I'll probably give people a second to get here. In case anyone's running a little bit late. So I don't know anything about this case, which means that if you do know a lot about this case and you hear me not understanding stuff, you're probably going to hate me. But that is kind of the nature of the beast on this one. Hey, Weppy. It's kind of the hardest thing about writing an appeal brief when you know the record really well is getting all the facts in, because you know the facts so well that the stuff that is... Yeah, Alan, I saw that. I saw you on Twitter. Hope you don't have any faith in life in the courts today. I don't have faith in either of those things any day. Especially this week with Fonnie Willis's performance. Not that that really changed my opinion on Fulton County. But yeah, I think that writing the facts on an appellate brief when you know the facts well is really challenging, because you won't spot holes or gaps because your mind just fills them in with the record that you know so well. So hopefully somebody not knowing stuff might continue to not know stuff if there are any holes in the brief. Hello, Matthew. Okay. Vague ambiguous. Oh, hey, Kat. Thanks for... I want to thank Kat for starting the jokes about me being blind. That's deeply appreciated. Oh, my goodness. Okay. I guess I'm going to get started now. Here we have Richard Allen. We're not angry, just let down by the system. Well, you can do both. No reason to limit yourself. You can be angry and let down by the system. Appellate's Brief, Mark Lehman. I don't know either of these people. Hey, Tay. I know you guys. Stacy's email is underlined, so she's probably more important. Catnot Williams in chatting. Totally fair to be enraged. Let's see. I was hoping Andrea would like give an analysis before I went live, just so I could steal her analysis and pretend it was mine. I'm gonna have to walk on my own on this one. Okay, so we're going to, this should, in general, table of contents should read like a outline of your argument. So hopefully I can read this table of contents and know where they're going. Authorities, issue, case, argument. The trial court committed reversible error by admitting evidence seized from the unconstitutional search of Allen's home and denying a Franks hearing. That seems like a couple of different things. The trial court erred by concluding Detective Liggett did not make false statements or reckless omissions in his affidavit. Okay. That's something to be an uphill battle because it's a finding of fact by the court. But okay, Detective Liggett omitted and changed key information that undermined his conclusion Allen was bridge guy. Bridge guy? I do know that there is a bridge guy in this case, but it's kind of weird to see bridge guy with no context. Detective Liggett's omissions and false statements recklessly misled the judge. With the omitted and accurate evidence, the affidavit was insufficient to establish probable cause. Error requires reversal. Okay. At minimum, Allen is entitled to remand for a Franks hearing. Okay. I mean, I do know who bridge guy is, but it's strange to just plop it into the table of contents like that. Okay, the trial court erred by admitting statements Allen made while gravely disabled during his unprecedented pretrial solitary confinement in a maximum security prison. Again, that seems like more than one thing. Okay, standard of review. Trial court abused its discretion by refusing to... What? This seems unrelated to... Abuse of discretion by refusing to admit evidence? But the section's about admitting evidence. That's kind of strange, but okay. Into the suppression hearing. What's suppression hearing? I thought there was no... Okay. The state failed to prove Allen's statements made while gravely disabled were voluntary. Okay. The U.S. Constitution. The state failed to prove that Allen's statements were not a product of psychological coercion. Prolonged solitary confinement was state action. That seems fair. Prolonged solitary confinement was psychological coercion. Okay. Confessions were a product of solitary-induced psychosis. Okay. I guess, and therefore not voluntary. Indiana, state failed to prove Allen's statements were a product of rational intellect rather than the state's misconduct. Most of my statements aren't the product of rational intellect. But, okay. Even if the court finds the statements voluntary, they are a product of unconstitutional detention. That's interesting. Okay. Allen's prolonged solitary violated Article 1, Sections 12 and 15. The violations require suppression of the statements. The error was not harmless. Okay. The court denied Allen his right to present a complete defense to explain the scene and impeach the investigation. Okay. Okay, I'm super nitpicky about this stuff, but this... Okay, wait, no, that's not what I wanted to highlight. This one. They call it the trial court up here, but then... The court. But okay. The court denied Allen his right to present a complete defense to explain the scene and impeach the investigation. Standard of review. The court committed reversible error by excluding Blair's sketch of Bridge Guy. Capitalized this time. The court committed reversible error in excluding Tobin's testimony. The court committed reversible error in admitting hearsay to rehabilitate the timeline, upon which this feels like a different thing. But okay. The court committed reversible error by excluding evidence that impeached the credibility of Allen's confessions. Okay. Erred by excluding the audio from his solitary confinement videos. That seems like a problem. The trial court committed reversible error in prohibiting the jury from hearing 2 phone calls Allen made on April 3rd, 2023. The trial court erred by excluding the statements and behaviors that provided the foundation for Dr. Grastian's opinion that Allen's confessions were not credible. That's true, Andrea. You're right. Let me see. Where was I? When excluded. Okay. The trial court committed reversible error when excluded Allen's evidence explaining this murder as a ritual killing. Hey, Kat. The defense attorney is good with me. This case bothers me so much. Can't be okay to treat a pretrial detainee. Yeah, agree with that. I generally think the statement of facts wins or loses the appeal. Okay. Look at all these cases. There we go. I like this one. I like me some Glossip. In Ray Winship. Remember that from the first week of law school. Okay, so this is something I looked into last night because I did read the table of contents last night. Apparently in Indiana, they do alphabetical order for Roman numerals, and that is psychotic behavior. But that's how they do it. I'm not going to try to read that. Let me see. They asked for a word extension. Yeah. I had one of those about this length recently. Statement of issues. Whether the search of Allen's home was unconstitutional and the resulting evidence inadmissible because law enforcement omitted or altered key facts in the warrant application. Okay. Whether statements made while gravely disabled during unprecedented pretrial solitary confinement were involuntary, the product of unconstitutional detention admissible, whether the trial court denied Allen his right to a fair trial, to present a complete defense to explain the scene and impeach the investigation. Okay, on October 28th, 2022, the state charged Richard Allen with 2 counts of felony murder by kidnapping, which was amended on March 22nd to add 2 counts of murder. Oh, wait, I need to get my appendices ready. Where are you? Sorry, I just need to get past the Georgia section. Okay. Appendix 2. I'm not going to check all of them. I just want to make sure I'm in the right section. Okay, this is whatever they call information. All right, there we go. On November 11th, following a 25-day trial, the jury returned a guilty verdict on all counts. The trial court sentenced Allen to an aggregate sentence of 130, filed a motion to correct errors. I'm guessing that's probably like a motion for new trial or something like that, which the trial court denied. Statement of facts. Okay, Andrea says this is the make or break. On February 14th, 2017, 14-year-old LG and 13-year-old AW were found dead in the woods. Okay, 2 days later, Allen, like many others, came forward and reported he had been on the trail that day and saw 3 girls. Because law enforcement wanted to know whether he had seen any possible suspects, he was interviewed in a parking lot. Because law enforcement wanted to know whether he had seen any suspects, he was interviewed in a parking lot? It seemed like unrelated things. But after the interview, the lead was marked cleared and the report was misfiled. Okay. Misfiled? How? That's weird. Okay. Allen then returned to his job, family, and home in the small Delphi community. For the next 5 years, he did not sell his car, destroy his clothes, dispose of his gun, or relocate, but continued his normal routine. No witness identified Allen as Bridge Guy. So again, I know who Bridge Guy is, but the judge isn't going to know who Bridge Guy is. It's a weird defined term to sneak in there. When the report was rediscovered in September of 2022, law enforcement insisted Allen was Bridge Guy without a single eyewitness. Over the next several years, the state built its case against Allen. Okay. Wait, it was in February. Okay, 13th was the day. On February 13th, 2017, around 1:30 p.m., LG's older sister dropped off LG and AW at the Monon High Bridge trial to explore and take photos. Should Bridge Guy be Bridge Guy? I mean, it's just weird to just drop that in at the start. I don't know what the Monon High Bridge trial is, though. The girls had the day off from school, and the weather was unseasonably warm. Okay, 13th. So 13th they went missing, 14th was the... Okay. When the girls failed to meet LG's father at the specified time and no one could reach them, LG's family contacted police and an extensive search began. The next day, Be the 14th, I guess. The next day around noon, the girls were found murdered in the woods near Deer Creek, not far from the High Bridge. The best evidence law enforcement had was from LG's phone, found at the scene under AW's body. So I'm guessing I have the appendices, but I'm guessing the transcript was filed separately because I couldn't find either the transcripts or the exhibits, which I assume were to the transcript. At 2:13:51, LG recorded a 43-second video showing AW walking across the bridge with someone, bridge guy, behind her. Law enforcement enhanced the video, yielding the following. Okay. The man is heard, bridge guy, telling the girls down the hill. Ooh, I should tell people I'm live on Twitter. It's too late for that. Law enforcement set up a tip line and many people came forward. 16-year-old RV, her sisters IS, AS, and BW told police that they were on the trail, and as they were leaving, they saw a man near the entrance to the Freedom Bridge. I don't know what the Freedom Bridge is. Betsy Blair, who frequently walked the trails for exercise, came forward and told police she saw a man on the High Bridge standing on a platform and seemed to be waiting for someone. She thought the man was the guy in the video, bridge guy, because he was wearing the same clothes. The same clothes as... So the guy that she saw on the bridge was wearing the same clothes as the guy in the video. Okay. When she reached the bridge, she turned around and noticed two girls approaching. Okay, so she was approaching High Bridge. Okay, got it. 4 months after the murder, law enforcement interviewed Sarah Carbo, I'm guessing. She told police that on February 13th, while driving eastbound on County Road 300, she saw a muddy man wearing a tan coat walking west. Okay. After seeing the image of Bridge Guy in the media, Carbo said he possibly was the man she had seen. 5.5 years later, Richard Allen. On September 21st, 2022, law enforcement rediscovered the tip from Allen. Let me see. Bridge Guy should definitely be Bridge Guy. The questions relevant to Bridge Guy is BG the killer and is Bridge Guy actually Richard Allen? I just mean they can call him anything they want to. They don't have to literally call him Bridge Guy. It's just a weird term to use. Let me see. On September 21st, law enforcement, I read that already. In the February 2017 tip, Allen called and said he was on the bridge. I thought Allen did an interview in a parking lot. He called? He was interviewed in a parking lot. I don't know what he called. Okay. Where was I? February 2017 tip. Allen called and said he was on the bridge between maybe 1 and 3 o'clock and saw 3 girls. Okay. Allen shared his address, phone number, and his phone ID. Okay, so this is what I was talking about when I said that, like, you guys know stuff that I don't know. But just reading this for the first time with no knowledge, it seems strange to be using the term bridge guy. That's the point of what I'm trying to make. And, like, you remember the judges that are going to be reading this aren't going to know the term. Until they're done reading this, presumably. The lead investigators immediately started investigating now 50-year-old Allen. They believed that the man the four girls saw on the trail was Bridge Guy. Alan still lived in the same house and worked at the same CVS store in Delphi as he did in 2017. Not in my Spoilers. Spoilers is fun. On October 13th, 2022, when police showed up at his house, Alan agreed to talk with them. After riding to the station with police, Alan patiently awaited answers about his personal life and the walk he took on his day off 5.5 years earlier. Alan explained after spending the morning with his mom on February 13th, he went home to get a jacket before going to the trails. He walked out to the first platform of High Bridge, looked at the fish, and then walked back before returning home to watch the stock market. As one does. He explained that he came forward after law enforcement asked to speak with anyone who'd been on the trail. The next day, a DNR officer interviewed... DNR, I don't know what that means. The next day, a DNR officer interviewed him in a parking lot. Alan believed he told the officer he was on the trail between noon and 1:30 or 1:45. He could only recall seeing three girls leaving the trail. Yes, never talk to the police. You can talk to them, just get a lawyer first. Being 5 years past, Alan could not remember what car he drove or the clothes he wore. That makes sense. He remembered wearing blue jeans and a jacket. When asked what type of jacket, Alan did not remember and listed all the jackets he owned. A blue Carhartt, a black Carhartt, or off-brand. That's kind of shady. It's either Carhartt or off-brand. Damn. Carhartt or off-brand with a hood, sweatshirts, hoodies, and a fleece. He kept a skull cap in his jacket. He could have been wearing tennis shoes or boots. When law enforcement asked for consent to search, Alan expressed concern that they were making him somebody's fall guy by trying to fit pieces together that do not fit to close the case. He was confused, thinking they were talking to him to look for helpful information. Although he understood they had to clear everyone on the trail, he was bothered by the time passage. After a break, law enforcement returned more confrontational with Alan, who became frustrated with being accused of murder, and law enforcement contacting his wife and daughter while he was at the station. Confronting Alan with the Bridge Guy photo, Alan responded, "If that is taken with the girl's phone, that is not me. I've never met those girls before." Carhartt is expensive. I'm just saying, like, you can't divide jackets into two categories, Carhartt and off-brand. There's like LL Bean. You get other options that are, outside of the off-brand spectrum. As long as you don't say the YSL of Royal America, I'm fine with it. Okay, they accused Alan of admitting he wore the same clothes as Bridge Guy. Let me see. And Alan corrected the investigator, reminding him that said he could have been wearing a sweatshirt. Alan added that everyone has looked at the Bridge Guy photo for years. To him, it did not even look like Bridge Guy was wearing a Carhartt. Finally, when law enforcement accused him of either being out there to kill the girls or introduce them to someone, Alan said, "Good luck finding anything that points to that." Despite Alan repeatedly telling law enforcement, "Arrest me or take me home," they would not stop. Alan eventually had to get up and walk out to end the interview. Let's see. The story Detective Liggett told the judge. On October 13th, 2022, the state applied for a warrant for Alan's home, car, and electronics. Hold on. Okay. In Liggett's probable cause affidavit, he concluded that Alan is the last individual to have contact with LG and AW, and is the individual depicted on the Modern High Bridge from the video taken from LG's phone. He reasoned that Alan admitted he was wearing a blue jacket and head covering like Bridge Guy, and was on the trail bridge around the time of the abduction, and witnesses saw a man they believed to be bridge guy wearing a blue jacket. Detective Liggett implied Blair and the girls saw the same man because they similarly described his jacket. Okay. Also, Liggett concluded that Allen drove his black Ford Focus and parked at the old CPS building on 300 North. He claimed that witnesses saw Blair and Wilson saw a car. Hold on, I'll write these names down. Wilson felt the driver of the car was trying to conceal the license. Wilson said the car was a purple PT Cruiser or small SUV. Wilson said that? Blair and Wilson drew a diagram and had the vehicle they saw parked in the same general area and manner. The part of the story Detective Liggett did not tell the judge. Blair's description of bridge guy did not match Allen. From what I've seen, Richard Allen looks like pretty much... That's fair. Liggett did not tell the judge about the differences between Blair's description of the man on the bridge and Allen's appearance. Just 3 days after the murders, Blair described the man as white, age 20, of medium build, and having brown curly hair. An artist completed this sketch, which Blair rated a 10 out of 10 for accuracy. Do I know who that looks like? Can't think of anybody. Missing lips. In 2019, Detective Liggett interviewed person. This is just later on, right? Yeah, 2017. Okay. In 2019, Liggett personally interviewed Blair, who again described the man as slender, youthful, boyish looking, in his 20s to early 30s, no facial hair, and with poofy hair. No facial hair and poofy hair. That might be Luigi. Luigi is youthful looking. He's boyish. He's slender, no facial hair and poofy hair. I think it's Luigi. I'm sorry, guys. It is what it is. I'm just shooting straight here. Okay. All right. At the time of the murders, Allen was 44, 5'6", and had very short hair. Bushy. Let me see. Nah, those are actually pretty nicely... These might be needle, actually. Those are nice. Okay. Blair's description of the oddly parked car did not match Allen's. Allen's car, right? Not Allen's description. Detective Liggett also admitted Blair's description of the oddly parked car as resembling a 1965... Oh, what? I don't even know what that looks like. Hold on, I need to Google something. Oh, that's nice. I mean, not for a murder, but that's a nice car. Okay. Coming back to my little thing. It's swaggy. I also had to Google. Fair. All right. Below is her drawing of the car compared to Allen's hatchback. That's a drawing of a car? Oh, share with the class? Hold on. All right. Where is my... This is it right here. That's nice. Okay, back to PDF. This is like... Okay, we got a face. We got a car. We can do a lot of stuff with that. All right. Blair also said the oddly part car was a nondescript color. What does that mean? These are the worst fucking witnesses. You could just say you don't know. Like, saying I don't know is really the most nondescript color you can give, but not black. Okay. So camouflage. All right. Blair did not believe the man on the bridge was the same man Carbo. So Carbo was the one who saw the man in the tan coat walking down the road. I know stuff. Detective Liggett omitted that Blair told him the man Carbo described walking down the road is not the same man she saw on the bridge. Okay. Below is Carbo's sketch. Who does this look like? It kind of looks like a bear. So I'm asking Gemini to generate me a picture of a bear with one of those hats on. Shut up, cat. You don't know me. Okay, this is what I was talking about. This is my first try. No, not you. You're so annoying. This guy. See, this is what it looks like to me. That's basically the same person. That was my first try. Can you, is it like propensity evidence if you admit evidence of like a bear eating a salmon? You might not be able to, that might not be admissible. Prior bad acts of the bear. Did I ask for the force background? I did not. Do you want to see my, I asked, my query was show me a bear in an Irish flat hat thing, because I couldn't think of the name of that type of hat. I said, show me a bear in an Irish flat hat thing, and that's what it gave me. Okay, I'm sorry. I'm getting sidetracked here. After talking with Blair, I can't even remember where I am. After talking with Blair in 2019, I'm guessing that's Indiana State Police issued a press release distinguishing the man Carbo saw from the man on the bridge. They explained the men are not the same person and that Blair's sketch is representative of the face of the person captured in the video of LG's cell phone. This is Blair's sketch, right? No, this is Carbo's sketch. So this isn't, it's not the bear. So, to be clear, Indiana State Police have cleared the bear. All right. Allegedly. Blair's sketch is representative of the face. Okay, so Blair, so Luigi is Blair, right? Yes. So Luigi equals Blair. Well, that's bad. All right. Got it. Okay, Carbo said the man walking down the road was wearing a tan coat. I do remember that from above. Leggett also made false statements in the affidavit. He claimed that an interview was done of Carbo in 2017, and she stated that she saw a man wearing blue-colored jacket and was muddy and bloody, dripping in blood. 13120. In her 2017, did not describe the man as bloody, only muddy. Guys, we're not here to snitch on the bear, okay? This is a no bear snitching stream. Although, if the bear needs a defense lawyer and wants to pay me a retainer, I'll defend the bear. I do remember the masturbating bear. Yes, I do remember that from up there somewhere. All right. Alan never said he was wearing a blue Carhartt, and his wife said Alan had purchased his current Carhartt a couple years earlier. From what year are we in? What state I operate in? Mostly California. And by mostly California, I mean I'm licensed in California, but people keep trying to get me to work in Georgia. So half and half. Nice. Go kill somebody. That's a joke. I don't want to say that on video. From 22. Okay, that makes sense. Okay, so a few years before 2022, but not before the murder. Liggett falsely stated that Alan said he's wearing a black or blue Carhartt with a hood and a head covering. A hood and a head covering. Okay. Alan told investigators that he did not know what he was wearing, and it could have been anything from a Carhartt to a sweatshirt, and that he kept a skull cap in his jacket. Yeah, I remember that from before. Although Alan's wife said he had a blue Carhartt in 22. Liggett left out the couple years ago thing. The girls were killed on February 13th, 2017 at about 1:30. I know I said it, Dr. Von Decay. I'm going to delete all this after this. They said he has accessories. Okay, the trial court issued the warrant. Law enforcement seized from Alan's home multiple items, including a Sig Sauer gun. Based on what I've seen from, what's-his-face, Runkle of the Bailey, a Sig Sauer is just as likely to hurt you as anybody else, so I don't know if that's helpful. Knives, casings, and the Carhartt-type jacket with a white and yellow patch on the front pocket. These items featured prominently during Alan's trial. Sorry about that, Vague. That's my bad. Alan denies the bullet is his, that he was bridge guy or had anything to do with the murders. It's always a 40 cal. I swear to God, every single case it's a 40 cal. I think the last 3 cases I've looked at have all been 40 cals. I know that the Atlanta Police Department used 40 cal as their standard issue for a long time. I'm sure that has nothing to do with any of those things. At the scene, officers found an unspent 40 cal Smith & Wesson cartridge near LG's right ankle. When ISP analyst Melissa Oberg, new name, cycled 6 cartridges through Alan's gun, she did not find any marks that matched the marks on the cycled round at the scene. Thus, she could not establish a link between Alan's gun and the unspent round at the scene. I can already tell this is going to be stupid. It already is stupid, but it's going to be dumber. Oberg then fired 4 cartridges from Alan's gun. She compared the markings on the spent cartridges to the markings on the unspent cartridges and concluded that Alan's gun was the source of some of the markings. So stupid. On the unspent cartridge at the murder scene. Oh my goodness. Wait, what did Kat say? There's this one case in Tennessee. Did the gun go boom, 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 as guns do? Okay, after learning of Oberg's conclusion, on October 26, 2022, Tounk was in Rice Street. Law enforcement interrogated Allen again. For about 1.5 hours, Detective Holman accused Allen of killing AW and LG, or at least being involved. I can work Tounk into anything. Don't doubt me. For about 1.5 hours, Detective Holman accused Allen of killing the girls, or at least being involved. Allen explained the very day the police asked anyone on the trail to come forward, that is what he did. This kind of reminds me of Wolfenbarger. Literally, no one doubted you. Shut up. I went for a walk on the trail and went home, and I did not murder 2 little girls. Am I capped at 5? I think I have a few more, but I haven't picked like what judge I want to do that will not be offended. For emoji usage. Thank you, Kat. He's capped at creativity. I'm very creative. I've used so many different YSL lawyers for emojis. Okay. So he said, I went for a walk on the trail and went home. I did not murder 2 little girls. I'm just kidding. I don't know you. I know, I'm just being difficult. You're actually probably right. Detective Holman repeatedly confronted Allen with Oberg's conclusion that marks on the casing at the scene matched his gun. Each time, Allen denied that the bullet at the scene was from his gun. Oh, there we go. There's my guy. So, match some at the scene, but not all. It seems like the gun didn't... Okay, first of all, the stuff doesn't like... That's not how... Gun forensics are incredibly shaky to begin with. But matching a fired cartridge to an unfired one and then saying it partially matches, that's just a lot of words to say it doesn't match. Holman even claimed that the methodology was scientific and like fingerprints. Oh, man. Exhausted and frustrated by Detective Holman's relentless accusations that he murdered... You can give spoilers if you want to. Said he could not tell him what happened to the girls because he does not know. He did not know how that round got between the girls or how they died. He emphatically stated, I did not murder 2 little girls. Despite Detective Holman's lying about experts identifying Allen and his voice on the video, Allen continued to deny he was a bridge guy. Detective Holman tried a different lie, saying 5 witnesses saw Allen with LG and AW and a gun. Didn't happen. Stressed out again. I'm not even going to read this. It's too dumb. I'm going to read it because I have to. Detective Holman tried to use Allen's depression against him, claiming it was because he killed 2 little girls. That did not work. That doesn't even really make sense. Usually it would be like you're depressed and so you did the crime, not reverse. Detective Holman even used Allen's wife as an interrogation tool. While Allen was being interrogated, ISP told her that the bullet at the scene matched her husband's gun. When they brought her in to see Allen, he hugged her and said, it's going to be all right. While left alone together, she asked how his bullet got at the scene, and he repeated what he told Detective Holman. I'm not going to say something I did not do, and I can't explain something I don't understand. I know that no bullet from my gun was connected with the murder in any way, shape, or form. ISP lied to Allen's wife too, telling her that a witness identified Allen. Allen assured her they're not going to get away with this. I'm sorry you're having to hurt. Sorry you're having to go through it. Westville, solitary confinement. Wait, how did we get to arrest already? Just a few days after 50-year-old Allen was arrested for the first time in his life, he was sent to DOC as a safekeeper. IDOC transferred him to the Westville Correctional Unit, a maximum security segregation unit for the worst of the worst. The movies? The movies refer to it as the hole, used mostly to punish. I actually don't know if that's as true as it used to be. These are for PC a lot these days. Allen was the first safekeeper in any IDOC employee's memory to be placed in WCU. Pretrial safekeepers with mental health issues are usually placed in a mental health unit. The IDOC knew Allen had major depressive disorder and was hospitalized in 2019 for suicidal ideation. He received a D mental health code, the second most severe, entitling him to one out-of-cell psychologist visit weekly. During the visits, he was shackled and confined in a cage, separated from a psychologist. Allen had no face-to-face interaction unless shackled or separated by bars. Outside his cell, he was restrained with leg irons, handcuffs, and a belly chain on a lead. Other Westville inmates in general population lived in dorms, played games, ate together, watched TV, and moved more freely. Allen was placed in a strip cell, striped of everything but the bare necessities. Allen's cell was 8.4 by 12.5 with a camera, a mattress on a concrete slab, and a bug infestation. His only view was a narrow window facing a razor wire fence. Meals were passed through a door slot. He ate alone on the floor or bed. Allen was recorded 24/7 with suicide companions outside his cell door, writing down his statements and behavior. And guards with video cameras filming his showers, movements outside the cell, and attorney meetings. IDOC knew solitary confinement could worsen Allen's MDD and even cause psychosis, and their policy restricts the time inmates with serious mental illness can stay in solitary to 30 days. But IDOC did not apply that policy to Allen, and he remained in the most secure solitary cell for 13 months. Allen's decompensation. On arrival at WCU November 22, Allen appeared like a deer in headlights, but was coherent, quiet, and weighed 180 pounds. By April 23, he weighed 135 pounds, was psychotic, and gravely disabled. Somebody asked me this earlier. I am curious about whether they define this term. If it's just a term of art. Early in custody, Allen maintained innocence and believed solitary was meant to tear him down. He told the psychologist, Dr. Walla, he felt like a broken man after 2 weeks. Allen described a quiet, normal life previously. Allen was extremely devoted to his wife. On November 14th of 22, he emotionally told her, if this becomes too much for you, call the detectives and I will tell them whatever they want to know. Oh, the term they used. Okay. By January 26th of 23, Allen was expressing paranoia. In late March and early April, around the time Allen received his discovery and met with his attorneys, Allen's behavior suddenly worsened. The guards thought he was acting up. He refused meals, became nonsensical. What did I tell you? I told you guys. How long have you guys been working on this? Okay. Is there really a bear emoji? Spoke of old Bear Claw hypnotizing him and acted like he was from medieval time. I'm sorry, this is really inappropriate for me to be laughing at this particular paragraph. That's my bad. If I had known that it was going to go here, I probably wouldn't have made that joke. He ripped illegal mail, washed his face in the toilet, and drank toilet water. He stuck a spork into his genitalia and covered himself in feces, spit, and vomit. Video from early April showed Alan frightened, extremely thin, bleeding, shaking, contorting, and interacting with non-existent stimuli. He was pacing back and forth, eating his Bible, and hitting his head on the cell door. On a video from April 12th, this is 22, right? 23. On a video from April 12th, he was naked while he flapped his hands, punched the air, counted imaginary objects, pulled feces from his anus, and smeared it into food and marched in place. By April 13th, Alan's health had... Is that the same? April 13th, okay. His health had become dire. The psychiatrist saw him naked, covered in feces with brown fluid from his mouth from eating it. Dr. Martin found him very psychotic. Hallucinating and incompetent to consent to treatment. On the 14th, don't just look at the 12th. Okay, 12th, 13th, 14th, the IDOC ordered involuntary medication and found him gravely disabled. Okay, a working diagnosis of MDD with psychosis. He had lost an abnormal amount of weight and was not sleeping. Haldol produced minimal improvement. He continued to speak in loose associations about things like nuclear war, poisoning, dying, losing reality, cryogenic eyeballs, and not remembering confessions he had already given. He also continued to play with his feces. After letting Alan sit in his feces for 2 hours on April 23rd, he was removed from his cell and given a shower. Alan's symptoms continued through May. On the 3rd, Dr. Walla diagnosed Alan with a brief psychotic disorder. Wait, which one's Walla? I know there's Martin. Is Walla also IDOC? Or is that different? I know they said it up here somewhere. Could have sworn I saw that name already. They're both IDOC. Okay. Okay. 12th, I know it was the 23rd. Okay. So in his speech behavior, no delusions. On May 25th, his shot was still not working. I'm guessing it's the Haldol. Alan paced for 2 hours and banged the back in front of his head on the metal door for about an hour. Despite his self-injury and a visible goose egg, no one checked on him. I mean, unfortunately, this is not... okay, got it aired here. This is not stuff I haven't heard before, unfortunately. Okay. The next day, he had 2 black eyes from banging his head, and on June 5th, IDOC was administered another 30-day involuntary emergent Haldol injection. The 30th and the 16th? I know. I have heard of this stuff for pretrial detainees. On June 20th, prisons are often better than jails. On June, I mean, I'm not going to get into a which is worse. But there are bad stuff everywhere. I mean, the Fulton County Jail was just put under into a consent decree with the Department of Justice because people were literally left to die and eaten alive by bed bugs, and their cause of death was literally infestation of bugs in their skin. And it was a systemic thing. Somebody was just left abandoned to die. So this stuff does happen. Did I follow it when it happened? No. I mean, I'm vaguely aware of it. On the 20th, he was catatonic and extremely skinny. Guards carried him to the infirmary, strapped in a chair. After his visit, he remained vacant while staff wiped drool from his mouth. That same day, Dr. Martin claimed Alan was coherent. My dog's really upset. Okay. That same day, Dr. Martin claimed he was coherent, oriented, not psychotic, and had been free of psychosis for 7 weeks, returned to baseline on May 2nd. This is 23 still. Alan confessed to his family over the phone April 3rd, May 10th, May 17th, June 5th, and June 11th. So that's within this period of time. On the 3rd, he told his wife, I did it. I killed them. Later saying, maybe I did it. I think I did. On May 17th, Alan, don't change the subject to Andrea's kittens. On May 17th, Alan insisted to his mother he killed the girls. The next day, on May 18th, Alan banged his head against his cell door to the point he had a gash. On June 5th and 11th, Alan told his wife he did it, but that he has lost his mind. He is probably going to kill himself, feels like he's already in hell and does not understand what is happening. From April through June, guards repeatedly heard Alan confess, I killed them, amidst bizarre behavior. Okay, I'll get the puppy. Okay. His statements occurred while he smeared feces, rolled in it, drank toilet water, shouted at his shadow, sang, I'm not going to say that word again in case vague and ambiguous is still listening on speaker, paced, saluted, asked nonsensical questions, hit his head, and asked if he was dead. On April 29th, Alan made a more specific statement to a guard claiming he killed 2 girls in Delphi with a box cutter that he stole from and left in the trash at CVS. He was going to rape them, but he panicked and killed them. He said they were screaming just the day before he was covered in feces. Dr. Walla. On April 5th, Alan's emotions shifted rapidly. He questioned whether he was God. I do that all the time. He slipped a sheet under the door, wanting to confess to the warden. Later, Alan told Dr. Walla, I killed AW and LG. I'm sorry. He had intense eye contact, bizarre smiling, and circumstantial thought. Although he would go off on a tangent and sometime never return to the original topic, Walla claimed his confession was concise. That's really not something a psychiatrist should be doing. Alan said he was motivated by sex, but was uncertain whether he had sex with the girls. Alan also confessed to molesting his sister and daughter, claims contradicted by them. 2 days later, Alan asked Dr. Walla if he had confessed. On May 2nd, very tangential, repeating himself and jumping between topics. He said, I killed AW and LG. I will kill everyone. I will wipe out the whole world after I die. He mentioned World War III, was confusing nightmares and reality, thought he must have schizophrenia, was randomly saying methamphetamine and telling people, including Dr. Walla, he loved them. The day before, Dr. Walla was unable to have a meaningful conversation with him. On May 3rd, he confessed to following... Wait, we're kind of skipping around date-wise, aren't we? No, you can't touch the keyboard. Okay, May 3rd, he confessed to following the girls to the bridge when the bullet fell out. It just fell out? It's not really a thing that happens. It sounds like an excuse that I would like hear from somebody who shot somebody. It was like I was walking and the The bullet just fell out. I don't know what happened. It's prior. It is a prior constraint. Okay. He was going to do the thing, but saw a van. He crossed the creek, slit their throats, and covered their bodies with tree branches. He also said he feared missing Easter, thought his interactions with Dr. Waller were fake, and was paranoid about his safety. After entering a summary into Allen's record, Dr. Waller destroyed her notes. These are some Fulton County tendencies for sure. On May 10th, with Dr. Waller present, Allen told his wife, "I did this, I killed them," while also insisting he was losing his mind. He continued believing he was dead, that the world would blow up if he fell asleep, that water was poisoned, and that he was reliving the same day. Waller listened to podcasts about Allen 3 hours per day while commuting to work. Before Allen was arrested, she researched a suspect on the Audox database, and after she treated Allen, she posted on social media about his case. Yeah, I don't think you're supposed to do that. Hold on, let me Google it really quickly. Yeah, it says you can't do that. Okay. Beginning October 17th, 2024. It's my parents' anniversary. How nice. Surely nothing bad happened. The state tried Allen on 2 counts of murder and 2 counts of felony murder. During the 25-day trial, the state built its case against Allen on 7 points. What the jury heard. Bridge Guy. The jury saw the video of Bridge Guy on LG's phone. They also heard from 2 of the 4 girls. Got it. Blair and Carbo. Okay. After seeing the video, the witnesses believed they saw Bridge Guy on February 13th, 2017. Blair thought she saw him on the platform of the bridge. Hey, which one was... I thought Blair was the one that... Oh, no, I was thinking of Betsy. My bad. Okay. Blair thought she saw him on the platform of the bridge. She described the man as white, possibly in his 20s or 30s. This is Luigi, with brown, poofy hair and youthful or boyish appearance. Okay. She also believes she saw AW and LG approaching the bridge while the man was still on it. Blair's Fitbit data placed her near the bridge at the time of the video. Although Carbo in 2017 reported seeing a muddy man in a tan coat about 4 o'clock. By trial, she claimed the man was muddy and bloody and wearing a blue jacket. Also, surveillance video captured a car like Allen's driving down 300 North at 1:27. Prosecutor argued this was Allen shortly before he parked and walked to the trail. That Carbo saw Allen walking back to his car after committing the murders. Okay. At trial, no eyewitness identified Allen as Bridge Guy. The prosecutor, however, told the jury that Allen must be Bridge Guy because every witness is adamant the person they saw was Bridge Guy. There's no doubt in their mind. That feels like that should have been an objection. Ann Blair, according to the prosecutor, must have seen Allen right before the girls because Allen told us he went on to the Monon High Bridge out to the first platform, which is exactly what Betsy Blair told you. Okay. Trooper Harshman, that's a great name for an officer, who had listened to Alan's jail calls, believed it was Alan's voice on the video. This is jail calls. I could go on jail calls for hours, if not days. Bullet. The jury heard from a battle of firearms experts over the bullet. For the state, Oberg testified that when she matched test firings from Alan's gun to the unpent casings at the murder scene, she applied the Association of Firearm and Tounk examiners methodology. That methodology is step one, make it up. Step two, insist that you have science. How do you know what was most objected to? It'll usually say over objection or something. She gave an error rate for the methodology of 2.2%. Oh my goodness. That's so stupid. She discussed studies and articles that she reviewed to apply the methodology. Oberg admitted that the AFTE methodology is subjective. Of course it is. Like it's pattern matching. But she testified that in 17 years of applying it, she was unaware of ever making a mistake in identity. Of course, you don't think you're wrong. That's not how that works. Oh, man. I love these people. During closing, the prosecutor told the jury that she has never been wrong. That's kind of a bolstering thing. In fact, that's the definition of bolstering. For the defense, Eric Warren, an expert in applying the AFTE methodology, testified that comparing tool marks on an unspent cartridge with tool marks on a spent test firing is akin to comparing apples to oranges. And in his opinion, there was insufficient agreement on the tool marks to match his gun with the unpent casing found at the murder scene. Timeline. Christopher Cecil, she's some kind of forensics guy, I'm guessing, testified regarding the movement and health data on LG's phone. The girls encountered Bridge Guy at 2:13 p.m. and LG's phone stopped registering movement at 2:32. Okay. It's 2:13, 2:32. Okay. 131 to 208, 1600 steps, 208 to 218. Why did it go from steps to meters? That's so strange. 1682 steps walked, 414 meters in 10 minutes, and then 2 flights climbed in final movement at 2:32. The state argued that this activity overlapped with Allen being on the trails and Allen completing the murders and leaving the scene by 3:56, where he was seen by Carbo. Okay. Trying to think about how this ties back to the enumerations of error. Yeah, that makes sense, Andrea, but you'd think that, like, you would have both, like, steps, meters, and elevation. They're switching from steps walked to meters walked to, like, vertical traveling. It's just strange. The phone only measures going up, not down. Is this like a... Oh, what was that movie? A Shaun of the Dead thing? Like dogs can only look up? The phone can only go up, not down? Is that what it was? I think it was that. Okay. Allen contested this timeline through Stacey Eldridge, a former FBI forensic analyst. She testified that someone inserted wired headphones or an aux cable into LG's phone at 5:45 p.m. and removed it at 10:32 p.m. This would silence the phone. True. And she noted that an incoming phone call occurred moments before the headphones or aux cable were plugged into the phone, which would have silenced the call. True. So the call was at 5:45. Okay. In response to Aldridge's testimony, the state asked Cecil whether water damage could be responsible for Aldridge's findings. I mean, so could like a ferry. Over a hearsay objection, Cecil testified he Googled it during the trial and found some unspecified non-peer-reviewed troubleshooting forums reporting that water damage or dirt within the headphone socket could mimic headphones being inserted. You know what else? You know what else could have done it? The bear could have done it. All right, we're going to do my first self-indulgent ADD moment. Is it this one? No, not that. Ah, damn it. So this is the second warrant. Nope, not you either. Where's the first one? There we go. So the first officer, I did a Google search on the pill identifier, and then they got a smarter officer, well, relative term, to change it to a pill identifier search. Unfortunately, they had already put it into the record, so, you know. I also FOIA Jumbo because, you know, that's what I do. Okay. I did FOIA a dog. All right. Confessed motive. Did that fuck their kid? No. When the state arrested Allen, it had no explanation for the murders. However, let me close this. I'm not going to come back to that. When the state arrested Allen, it had no explanation for the murders. However, the state argued that once placed in solitary, Allen confessed to the crime and a motive. While gravely disabled, Allen confessed to... FOIA Chloe. I should. That'd be funny. Yeah, I FOIA'd the dog's training records. They were like service jackets because I wanted to know if they were qualified to like search for stuff. Allen confessed to the crime and a motive. While gravely disabled, confessed to guards, Dr. Walla, and his family. On May 3rd, he told Dr. Walla he was going to argue these girls, but panicked and killed them. He said they were screaming. The prosecutor argued that the jury should believe Allen's confessions, despite his psychosis. Okay, so the psychosis did come before the jury. It doesn't help. Relying on the opinions of Dr. Walla, the guards and Trooper Harshman, who reviewed his video and calls, the prosecutor claimed that Allen's confessions were logical and organized and the product of free will and his newly found religion. Yeah, that doesn't feel like that should have been admitted either. Almost every guard testified Allen's bizarre behavior was orchestrated and not the product of mental illness. Well, I mean, as long as prison guards said so, because, you know, they're experts on this sort of thing. One guard said he knew Allen was truthful in his confession because of the look in his eye. Some guards claimed inmates commonly smear or eat feces as a tool for attention. It's just, that one's, it's not funny because, like, the underlying fact of it. It's just funny that, like, the layers of that statement that you need to unpack. they commonly use it as a tool for attention, right? So like, why do they need the attention so badly that they're willing to eat feces forced at attention? Like, let's take you at your word, and it is like a conscious, volitional, rational act to eat feces. Like, isn't that indicative of some underlying problem that needs to be addressed? And if the underlying problem that needs to be addressed is so bad that you're willing to eat feces, then isn't that the same as it like no longer being volitional? Because like the rational act can be to give a false confession at that point. Yeah. I have a client that's been in solitary for 3.5 years now. Supposedly because it's for his own protection. But I don't know how being in solitary for 3.5 years can be for your own protection. How is he doing? He's doing okay. I've had plenty of clients that are not convicted that have been in solitary. Let me see. And even if they are convicted, it doesn't matter. They shouldn't be in solitary for 3.5 years. None are mental health professionals or knew Alan's mental health code. Each time Alan confessed to Dr. Walla, she said he was not delusional, hallucinating, or psychotic. Although Alan expressed confusion and memory gaps, she suspected he was feigning or acting bizarrely. On cross, she admitted she may have been wrong, and Alan might have been genuine. With hindsight, she was on the fence. The state introduced 31 suicide observation reports containing Dr. Walla's opinions. Except for a few, she continued to find Alan non-psychotic while documenting paranoid, delusional thoughts, confusion about being dead, and self-injury. She at times labeled him as feigning for secondary gain. The day before he was deemed gravely disabled, she wrote he could be exaggerating or consciously deteriorating. When he ate feces, she called the behavior unclear. Dr. Martin, the psychiatrist, believed Alan was psychotic but in remission after a mid-April Haldol shot and back to baseline by May 2nd. Like Dr. Walla, he described psychotic symptoms, yet concluded Alan was much improved. When other doctors acknowledged psychosis, they attributed it to factors other than solitary. Because Alan's phone call confessions, Harshman said Alan's demeanor was calm and solemn, and he was not under duress or stress. He opined Alan acted this way for attention. Alan called Dr. Westcott, a neuropsychologist, who opined Alan entered IDOC with MDD, and just physically and mentally decompensated, showing early... Okay, let me respond to this. Doesn't make sense. It's okay, I agree, but I think it's important to know this man went from work and eating dinner with his wife to one day being put into the depths of a prison's punitive solitary housing. Yeah, I mean, I'm not saying this is okay. I totally agree with that. Hey, Andrea, like, if I'm hiring, like, somebody to watch my dog, and it's like a dog sitter, and they say they're mostly psychotic, but not, like, all psychotic, it's cool. They can come stay in my house. Alan's solitary confinement, sleep loss, and starvation produced sensory deprivation, delirium, or psychosis. Dr. Westcott believed Alan was psychotic or delirious when confessing to Dr. Walla. After reviewing all records and videos and evaluating... Oh, yeah, that's all good. I will say it's one of the things that's hard to get used to in streaming is it feels like I'm just yelling at people in the comments because they can't like really respond to me because it's not like a conversation. So if it comes off that way, I don't mean it that way. After reviewing all records and videos And evaluating Allen for days, she found no evidence of malingering. Dr. Gracian, a psychiatrist experienced with solitary confinement cases, such environments cause psychotic delirium, confusion, disorientation. Delirious behavior often becomes grotesquely regressive, including smearing feces, sexual acting out, self-harm, and suicide. On recovery, memory is often absent. He had no doubt Allen was delirious and saw signs of a false memory, common delirium, where a belief evolves into a perceived recollection. Some people will say, I think I did it, and after time start perceptualizing the event. That's actually not just psychosis. That's just how memory works in general as well. It's one of the reasons eyewitness testimony is unreliable. Obviously, it's worse with psychosis, but most things are. Okay, cool. Thanks, Stevie. All right. The more someone tries to remember, the more concrete and distorted the memory becomes, like a game of telephone. Yep. A detail only the killer would know. Brad Weber. Fucking Brad. I will say that one thing that concerns me, I don't know how to phrase this, but the fact that it seems like all this stuff came out the jury, there was a battle of the experts, which might not be great for seeking relief. But we'll get to that. The state claimed, I'm only on 37? Good Lord. The state claimed that Allen confessed to Dr. Walla that he attempted to rape the girls, but was scared after seeing a van, which forced him to flee with the girls across the creek. Okay, Allen's statement. The state told the jury contained a detail only the killer would know. Wait, what? Brad Weber, he left around 2:02, 2:22. Okay, I see. The state argued Weber's arrival home in his van was what interrupted Allen, causing him to take them across the creek to kill them. I believe it's written, for sure. The murder scene was unusual and complex. LG was naked. AW was wearing LG's clothes, and his right leg was positioned underneath her left. Both girls' throats were cut with a sharp instrument. However, the injuries were different. LG had so many incised wounds along her neck that it was difficult to determine the number. 3 major vessels were injured. There was a scalloped edge along an incision. AW's throat was cut only once and not as deeply as LG's. AW was likely murdered while wearing LG's clothes. Yeah, I got that one, Goddess. It's kind of a weird... They're kind of assigning a lot of weight to a single van. AW died in the location she was found. But after LG died, her 200-pound body was moved several yards to its final resting place. This created a V formation with the girls' bodies. What are those lines? Ground. Sorry, I'm just trying to read it. Cartridge is what, here? This, I guess these are the sticks. Exposed dirt area. Tree. Okay. See, if I just read the next line, it would have told me there were sticks. That was very smart by me. Sticks were deliberately arranged on the girls, covering no more than 3% of their bodies. It would have taken up to 20 minutes for AW to die. Although LG's injuries were more significant, it would have taken her between 5 and 10 minutes. The blood pattern on AW's hands was noteworthy. When injured, people instinctively reach for major wounds, getting blood on their hands and sleeves. That makes sense. LG, but AW had little to no blood. Okay. The state's blood spatter expert had never seen clean hands and sleeves in a case involving this amount of blood loss. So what are they going to say? Her hands were, she was like tied up or something? The absence of blood may be consistent with unconsciousness or restraint, but there were no defensive wounds, bruising, blunt force trauma, or ligature. That's strange. The bodies were lying in the prone position, yet both girls' faces had blood patterns flowing upward against gravity and over their chin and face. Okay. Thus, sometime during the murders, a person articulated the torsos and necks above their chins. It was clear someone lifted the body to create the flow pattern. AW had a similar pattern. Okay, to close, 4 feet off the ground. About 4 feet off the ground, there was a notable blood pattern on a tree in LG's blood. Is this where we get to the, what's that shit called? The Viking stuff? It's that stuff, isn't it? Okay, state performed sexual assault kit and found no physical evidence of assault. That's the one. Despite testing the sexual assault kit, hundreds of clippings from the clothing and swabs of the bodies, cartridge cell phone, no DNA of Allen. State told the jury Allen controlled the girls, swapped their clothes, looked their bodies, and moved LG all by himself before fleeing the scene by 4 p.m. The state's witness repeatedly claimed Allen used the sticks as camouflage, but she didn't even cover them. And that's not even what camouflage... Okay. And he moved LG's body to make it harder to see. This, the state argued, caused blood to flow over the chin. And for reasons the state could not explain, Allen dressed AW in LG's clothes and turned and repositioned her at the scene, causing blood to flow from her neck and over her chin. Although the girl's injuries were different, possibly caused by multiple weapons or different mechanisms altogether, the state's pathologists speculated that a single blade, such as a box cutter, caused all the injuries, including the scallop mark. Bears with... The bloodstain on the tree, according to the state, was an inverted L. An inverted L transferred from LG's arm as she propped herself against the tree. Inverted... Okay. And a female hair and multiple include profiles were seen contamination or background DNA from the girl sharing clothes or through incidental contact with people they knew. Okay, according to the state, it could not find Allen's DNA because the blood from the girls was overwhelming the scene, competing with any DNA left behind. Hey, everybody. Ms. Garbage Brain. Okay, the manner, quality, and thoroughness of the investigation. At trial, the jury heard about the state's investigation from the day the girls went missing to a few days later when Allen met with Doolin. I don't remember that one. Which one is Doolin? The detective? In the parking lot, I think? Was that the parking lot interview? First state expert ever to attribute all the DNA to environmental transfer. True. The state then told the jury to fast forward 5.5 years to the volunteer finding Doolin's report in September of 2022. The jury heard nothing, maybe very little, regarding the manner, quality, and thoroughness of the investigation between the murders in February 17 and the arrest in 2022. I've always wondered, the U.S. box cutter, not the knife thing where the blade can be broken off in pieces. I think it usually is, but sometimes it's like a single blade. You guys see this okay? Yeah. All right. Back to Luigi. Sorry, Andrea, about the Luigi. He's innocent. The jury never saw the... Wait, sorry. I skipped this part. On November 11th, following a 25-day trial, a jury found him guilty of 2 counts of murder I believe also the felony murder counts. On appeals, below the evidence, the defense was prohibited from offering to the jury. What the jury did not hear, bridge guy. The jury never saw the sketch below, which is the man Blair saw on the bridge when AW and LG were approaching. The sketch does not look like Alan, who in February 2016 was... He was 5'6", that's not short. In February 2016 was 5'6", 44 years old, with closely cropped hair. In 2017, I remember reading that before, it was 10 out of 10. In 2019, she said it was 9 out of 10, I believe. She reaffirmed her confidence in her sketch and insisted that she could identify Bridge Guy if she saw him again. Nor did the jury hear that Blair, and at one point the ISP, believed that the man she saw, Bridge Guy, was not the man Carbo saw muddy and bloody. I am 6'1", but still, I'm standing up for my short kings. Hey guys. Oh man. Okay. I'm just going to walk into an interview with my ball that's just dragging the ground. Okay, the jury never heard that firearm and tool mark evidence is flawed and unscientific. Allen proffered expert witness William Tobin to explain the scientific community's criticism of the AFTE methodology. Tobin is a nationally recognized forensic metallurgist. You know, I have a problem. Like, we got to stop putting forensic in front of everything. You just gotta stop. I don't like the word forensic anymore. We get forensic everything, except for forensic accountants. They're cool. I have no bias on that. He has extensive experience in metallurgy, bullet and lead analysis, and tool mark principles, along with a background in statistics. He is familiar with the President's Council of Advisors on Science and Technology, which has criticized the AFTE methodology of tool mark identification. Let me see. Tobin reviewed Oberg's work and was prepared to explain the flaws in the methodology. He has testified in over 297 cases. Does that mean 298? Wait, what did Kat say? What's the Okay. Over 297 sounds like 298. He's been recognized by state high courts as an expert on this topic. Virginia Supreme Court confessed motive. The jury never heard Allen's confused, disjointed ramblings and screams during the months that Wallace said Allen was making logical and organized confessions. The trial court permitted Allen to play 15 videos of him in solitary to impeach his confession, but required Allen to mute them. This is going to be some dumb hearsay thing, isn't it? The excluded audio showed the following. Video 972. Guards extracted a skinny wad at Allen with blood on his forehead. Allen screamed for his dad, asked guards to hold for his hands, and yelled, "Roger, Marvin, wait for it." The 13th ordered him to cuff up. Naked and confused, he clutched the sink and shook. When they entered, he begged to be put on an airplane and told them not to believe his last confession. April 17th, and another inmate yelled, "Kill yourself, Richard Allen." 1007, during transport for forced injection, Alan screams, spoke incoherently, asked for his mommy and daddy, rambled about suicide and time travel, and within 7 minutes claimed to be both the stupidest and smartest person ever, and repeated, wait for it. Self-serving hearsay. Doesn't even really feel like self-serving hearsay. I mean, I'm sure you know that. Wait, how is that hearsay at all? It's not offered for the truth. It's not hearsay at all. Sure, I was trying to think of like hearsay exceptions. And then I realized, yeah. Games are over. Commented on feces on him. Rocky Balboa is my favorite actor. Okay. I assume he's talking about Stallone. If you think Stallone's your favorite actor, you're out of your mind. April 21st, during a haircut, Alan mostly stared into space, confused. He responded, leave the top, when asked if he wanted his face shaved. 28th, Alan spoke incoherently, repeatedly saying there is a God, please don't do this, and make it painless. With feces on his face, he asked to be euthanized, and whether his wife was present. He said he was King Michael, claimed he had started World War III, tried to save his family, and Donald Trump sang hymns, quoted scripture, and asked to be cryogenically frozen. This just sounds like Tiger King. Okay. Video 1201. Guards carried a catatonic drooling Alan to the infirmary. The medical professional discussed with Alan his cholesterol and blood pressure rather than his non-responsiveness and involuntary jerking. Alan asked this court to watch the videos with a sound, especially... Wait, when is 10:15 to April 28th? Also, the jury did not hear Alan the morning started confessing, tell his family in 3 intertwined calls that he was confused and losing his mind. Used to love Michael Rappaport. That's fair. In the first call at 3:12 a.m., Alan told his dad he was losing his mind and was uncertain how much longer he was going to be lucid. Alan said, you guys know I would never do something like I've been accused of. Alan felt he'd been mentally tortured, like he's in Guantanamo Bay, and that there were drugs in his coffee and Kool-Aid. Interesting. If I could pin comments, if I was smart enough to know how to pin comments, I'd pin this one about Haldol. In the call the jury heard at 5:14, Alan told his wife for the first time he thinks he killed the girls and eventually did it. Alan could not remember what he told his dad in the earlier call. Yeah. Then in a third call, 8:45, a panicked Alan told his wife he was not sure if his original call to her was a dream. He said he was not drinking the water or the coffee and questioned whether the attorneys who were coming to visit him were his attorneys. The jury only heard the second call with confession, along with Trooper Harshman's opinion that Alan showed no indication he was under duress or stress when he made that admission. I feel like I read these categories. Okay, these are the rebuttals. Okay. The jury never heard that Alan could not have walked the girls across the creek to kill them after seeing a van driving down a lane, as he confessed. The state had videos showing Weber's van arriving home 25 minutes after the pause and movement of LG's phone and nearly 15 minutes after it stopped moving altogether. Okay, so the deed was done by the time the van passed. Specifically, security camera footage from Weber's neighbor showed him arriving home at 2:44. And the state also had a report prepared by the FBI, which confirmed that Weber's cell phone arrived home around 2:50. The jury also never heard that Allen confessed to details that the real killer would know were wrong, including that Allen said he shot the girls. The judge prohibited Allen's expert, Dr. Gracian, from identifying Allen's signs of being in a state of delirium and hallmarks of a false memory. One such hallmark was the facts Allen got wrong. Allen's alternative exculpatory explanation of the scene. The jury never heard that from the beginning many investigators believed and investigated the girls' murders as part of a Norse pagan ritual, and that the unusual and complex scene had textbook features of such. There was always a discussion among law enforcement that this may be a ritual murder and that the sticks were I almost said Nordic runes. It is kind of nerdy, but Nordic runes. Also, many officers believed the scene was too complex for just one person to be involved. Within the first week, the Carroll County Sheriff enlisted the FBI's Behavioral Analysis Unit to evaluate whether the sticks related to pagan rituals. That's a sentence that has never been written before. Okay, I know it's Nordic. I had nerd in my head. After examining the evidence, the BAU declined to exclude pagan ritual as a plausible explanation for the murder scene. It remains possible a new believer or a rogue believer in Odinism was involved in this case. A Purdue professor also consulted law enforcement on whether these sticks were runically inspired. He found it quite plausible these markings constitute an instruction inspired by Norse runes or modern recreations thereof. Always blame the witches, I know. Law enforcement consulted with an undercover ISP trooper regarding the sticks and the bloodstain on the tree. The officer was familiar with Norse pagan symbols through his covert intelligence. His intelligence is very covert. And he agreed the blood on the tree resembled the pagan Fehu rune. Hold on a second. That's 3 lines. Okay. And he found similarities between these stick formations on the girls and pagan bind runes. Once Allen was charged with the murders, the defense team consulted a nationally recognized expert, Don Perimeter, who found 7 features of a Norse pagan ritual. They include location. She explained that Norse pagans follow a Norse pantheon of gods like Thor and Odin. They have nature-based ideology where events and rituals are conducted outdoors, in wooded areas, and near water bodies. This murder occurred outdoors in a clearing and near a creek. Date. Norse pagan rituals often occur on Norse holidays or events. The Nordic holiday Valisblot, which honors Odin's son Vali, begins at sundown on February 13th and continues until the 14th. The girls went missing near sundown. Yeah, I think that lines up with the timing of the cell phone, the insertion of the aux cable, right? That was at like 5 something, and then it was taken out at 10 something, I think. That was like 20 pages ago, if I'm not mistaken. Okay, good. I'm picking up some stuff. Means used. Ritual killings often involve a knife or a ceremonial knife. And here, the girls were killed with a knife that made an unusual scalloped mark. I thought only one of them had scalloping. Ritualistic crimes usually involve symbolism at the scene, and with Norse pagan, these symbolisms would include arranging natural objects in a specific way, like sticks and runes, and blooding the runes. Ron Logan, I don't remember that one. Oh, I got it. These practices are integral to the magical thinking. Here, the stick arrangement showed intentional symbolism. It is difficult to claim the sticks as hiding the bodies. That's true. They covered 3% of the body, I believe they said. They're absolutely not working that way. They're not functioning that way. The stick arrangement on an AW mirrored the Norse rune Gebo? And the intentionally placed stick formation LG looked like a Nordic bind rune. Manner of death involved blood loss and torture. They were caused with threats, prolonged blood loss. On Ron's property, okay. Arrangement makes sense. Upside down hanging is an important element of Norse paganism because Odin hung from a tree for 9 days before discovering runes. Like the positioning, the classic image of Odin depicts him with one leg bent behind the other. Unusual blood pattern. Finally, a ritual sacrifice would involve an atypical or symbolic blood pattern. Here, the blood pattern on the F tree appeared to look like a Norse pagan Fehu rune. Nick isn't even really Swedish. Don't let him lie to you. Nick's actually from Detroit. He just needed an excuse to have all that hair. The manner, thoroughness, and quality of the investigation. The jury never heard how law enforcement... Oh, man, somebody's going to clip that. The jury never heard how law enforcement bungled the investigation into the ritual killing or suspects connected to Norse paganism. ISP disregarded Brad Holder, the father of AW's boyfriend, and Holder's friend, Patrick Westfall. I'm sorry. Anytime I see Holder, I think of like Holder versus like Department of Justice Holder. It's just throwing me off. And Holder's friend, Patrick Westfall, as promising alternate suspects because they lost evidence, mishandled interviews, and conducted a poor investigation. Oh, man. This is, I like this. Oh, man. Investigation into ritual killing. It's Luigi, guys, or the bear. Whichever, it's one or the other. Investigation into ritual killing. After examining the scene, several officers believed the scene was too complex for just one person to be involved. When the BAU, that's the Behavioral Analysis Unit, see, I know things. Eric Holder, yeah. There are a lot of cases from way back when that were Holder versus appellate court stuff. When the BAU evaluated the murder scene, it found it noteworthy AW was clothed, allowing AW to dress ahead of time to suggest the suspect felt differently toward her, including a possibly heightened level of guilt or regret, at least compared to LG. Law enforcement explored a group of pagans connected to AW. In the weeks leading to the murders, AW had been talking with a boy, LH. Can I tell you guys something embarrassing? Andrea, if you're still listening, I'm going to need you to mute for like 30 seconds because I don't want to be judged. In a lot of immigration cases, there will be like LNU versus like, I don't know, whatever the government is, either Bondi or somebody like that. And I thought LNU was like a name that I couldn't pronounce, but its last name unknown. It's like, why is everybody... How do you say this? Lanu? I only learned this like a week ago. How did they not teach me that in law school? Which brings me to my second point. We need to stop doing caps lock everywhere. Because in the caption, if it was like regular, caps, capitalization, and then there was L and U in all caps, I would know. No, I did not go to UCLA. That was, what's his face? The doctor from the Karen Reed case. He's definitely a UCLA guy. Look at the blue paint that he used. Okay, back to it. In the weeks leading up to the murders, AW had been talking with a boy, always a mistake, and meeting up with him a few times. I did go to USC. Bye, Carrie. Thanks for coming in. She kept this relation secret. One of the days she was murdered, AW invited LH to meet her on the trails. We get Triple H. LH had school, so I thought school was out. How come did LH go to a different school? Did she have a boyfriend from a different school? But school was out on the 13th. And the weather was unseasonably warm. While law enforcement was searching for the girls on February 14th, there's more than one school. Was this like a different school district? There was like just this one school. This doesn't matter. I was just curious. I don't know why I'm asking this. I was just wondering. While law enforcement was searching for the girls on February 14th, they learned about LH and AW's secret relationship, pulled LH out of class in Logan. Oh, he's in Logansport. Okay. And searched his phone. That moment, LH texted his father, Brad Holder, she's missing. So Brad Holder is... Well, I know in the U.S. there's multiple schools, but usually you'd have the same days off within a school district. Lost in missing interviews. On February 17th, law enforcement interviewed both LH and Holder. By then, law enforcement already suspect the murder scene involved a pagan ritual. Okay. I've seen a couple people that don't follow the kids. Oh, yeah. I mean, I guess it makes sense if it's a small town that the boyfriend would be from, like, the next town over or something. That's not that weird. Right. During his interview, Holder reported being involved in a pagan tribe and spending every weekend in Delphi, engaging in pagan rituals with Westfall. Fuck, which one's Westfall again? I know I just saw that name. Westfall was the friend and let's start. So, AW is with... I'm guessing it's something Westfall. Okay. Where was I? 13 to 16 is a huge age difference. I can't believe that, like, the cops, like, on this, what was this, the 17th, I think? So on, like, day 3, they have somebody on an interview talking about doing pagan rituals. Like, if I was a cop, I'd be excited. There we go. Get this crazy guy talking about doing a bunch of rituals in the town where the people got murdered. Like, that's the easy way. These rituals involved animal sacrifice and human bloodletting. Isn't that just a crime in and of itself? Animal sacrifice? Maybe not. Holder... Well, yeah, you can't sacrifice a bear because it's going to throw those claws. That's ridiculous. Y'all got anything fun planned for the new moon? I need something to talk about on the news later. I mean, I might have a habeas. I think that's fun. Holder admitted knowing about AW and LH's relationship, but he denied ever meeting her. Law enforcement recorded Holder's interview, but the Delphi police recorded over their only copy before August 2017, permanently deleting it. Only a one-page narrative remains. I hate when they do that. There'll be an interview, and then there's a recording, and then they'll just delete it and be like, trust me, this is what happened, this written narrative that I wrote. According to that narrative, Holder told police he owned a .40 cal. So the gun was Smith & Wesson, or the cartridge was Smith & Wesson? But law enforcement never collected it, nor did they collect his cell phone. On February 19th, law enforcement interviewed Westfall. That is the father of the boyfriend, I think. They failed to record this interview. Only a 5-paragraph narrative remains. I hate when they do that. According to his narrative, Westfall knew the woods where the girls were murdered very well. He reported knowing the girls but denied ever meeting them. He also reported being a religious leader for local pagans, and he wore a necklace? Necklace to the... Is that like a like LACE necklace? Or was a necklace like a shirt of some kind? I assume it's like a necklace. Okay. I got it. Okay. Wore a necklace to the interview representing his efforts to pledge the Vinlanders a pagan social club. There is no indication law enforcement asked Westfall whether he owned a .40 cal. Westfall's phone was not searched at that time. Mjolnir. No, Mjolnir got destroyed in Ragnarok. Okay. They had to make the axe with the little tree thing. Alibi investigation. When asked for an alibi, Westfall claimed he was home with his minor son, and Holder told the officers he was at work at Liberty Landfill. Okay. On April 13th, officers visited the landfill to investigate and spoke with an employee, Susan Case, who provided a printout showing Holder swiped out of work at 2:45, which was 30 minutes after the bridge guy video. Case invited the officers to review video to confirm the printout's accuracy, but they declined, nor did they interview other employees. Unified Command? I'm not sure what that is. Unified Command marked Holder as a cleared suspect. Tipsters continued to identify Holder as bridge guy. Tipsters repeatedly called and reported Holder as a person of interest. Holder posts half-dead women and shows fascination with symbols out of tree branches. That is some very specific snitching. And I don't mean that in a pejorative way in this context. That's like really specific. Check the father of one of the girls' boyfriend. His name is Brad Holder. He also fits somewhat the description. Each time a tip came in, law enforcement marked it clear, nothing further, covered, or alibi confirmed. You should see the pictures. I would love to. I'm sure they're in... I think these exhibits... I know there's a footnote explaining what these are, the November exhibits, but I think the exhibits are mostly to the transcript, which I don't have. Sometime around March of 2017. That's funny. Whenever I think of dates, I think of them of like other cases to contextualize dates. That's a good point, Boogies. Yeah, you're right. You kind of proved my point wrong, didn't you? Sometime around March of 2017, Detective Purdy interviewed Holder to get his assistance in connecting the murders to Norse paganism. Because Holder was not a suspect, Purdy did not record or document this interview with a report. Unified Command. So you said Unified Command is like a, just like some kind of thing of the local law enforcement entities, I'm guessing. Maybe if you type your briefs in all caps, the courts will finally do the right thing. Not Adrian Love tried that. Unified Command declines to re-interview, despite reports Holder is posting pictures of young girls believed to be deceased with sticks placed over their bodies. March of 2017. Let me see. I believe he would have been in Rice Street because that would have been before the December 2017 guilty plea hearing where Adrian Love lied about the sentencing exposure. So I think he still would have been in pretrial detention. What was... I'll show you... after at the end of this, I'll show you one of her briefs that's just like every kind of emphasis imaginable. Okay. Declines to re-interview, despite reports Holder is posting pictures of young girls believed to be deceased with sticks placed over their bodies. April 12, 2017, shortly before taking medical leave, Trooper Winters recalled a sieve from a tipster, Ryan Boucher. That's a good question, Aaron. Who shared pictures from Holder's social media. Bro, it's like, you know what just upsets me about this? Is like there's so much there's more evidence against these guys than there is in any Fulton County case. Like in Fulton County, they'll use Instagram, but it'll be like the guy's just like smiling in front of a restaurant, and they'll be like, look at the way he's smiling. That's a gang smile. Gang. And then here, it's an Instagram photo, and the photo is it's a picture of a dead body. It's you want to see a dead body, but then he actually shows it. For those of you new to me, I have a client right now who had an overt act in furtherance of a criminal conspiracy in a RICO case. 15-year sentence, working on it. And one of the overt acts was somebody took a picture of him wearing pants with the letters OTS on it. That's all he did. Somebody took a picture of him wearing pants. And that was good enough. Overt Act 129, or 130? 130. No, 128. It's 128. And then they got, yes, pants. Self-indulgent moment number 2. We're going to the pants. It was a pant-based RICO. I hope I don't have any notes in this one. Here we go. It's right here. Defendant Antonio Sledge posed for a photo. That's how they make an act, because he posed for the photo. Then somebody else took the picture, released on social media, wearing pants, with the letters OTS, a.k.a. only the slime. That's not even what a.k.a. means, first of all. But then somebody else, they used a random person's caption. That's not even Antonio's caption. Somebody else posted the picture. And the caption. It's an unidentified third party's emojis. Antonio doesn't use emojis. This is about Lil Uzi Vert. It's about a diamond. This is defendant Jeffrey Williams. These aren't even his lyrics. These are random 2 other people's lyrics. Nobody on the indictment even said this song. Does he wear pants? Oh, man. He's only going to be wearing shorts after this, for sure. This is so stupid. Okay, back to the case at hand. I didn't know you were. Yeah. He's my guy. Okay, I'm sorry. I blacked out for a second there. Crash out. I hate how on YouTube everything's a crash out. Okay, I'm focused up. Here we go. April 12th, 2017, shortly before taking medical leave, Trooper Winters received a call from a tipster, Ryan Boucher, who shared pictures from Holder's social media. Heard a bit about the Franks hearing. Somebody told me to read the Franks memo, but I intentionally didn't, or brief, or whatever it is. Oh, thanks, Chuck. Winters found a concerning similarity between the murders and pictures posted on Holder's social media. Those pictures depicted young girls believed to be deceased with sticks placed over their bodies. A clue! He wore every color. I do remember. I definitely will. I think the memo's in the appendices. I also have it separately. I think it's in the first volume. Winters also noted a similarity between the stick formation on AW and a bind rune Holder tattooed or drew on his hand. Holder, that's a bind rune on my hand. Basically, I took a Gabo rune and an Isa rune. What is this, 21? I'm sorry, I just can't take this shit seriously right now. Isa rune, and I made a bind rune. Okay, this is... Holder's social media also featured him holding guns and homemade knives. Winters immediately recommended to his superiors that law enforcement investigate Holder further. You don't even need to investigate him further. You're already done, which they declined to do, claiming his alibi was cleared by the FBI. Winters was not satisfied and urged the ISP to conduct its own investigation. It feels like Winters is like really carrying the team here. Yeah, the bind rune's the one with the F1, right? That's the In 2018, Holder displayed a painting he made of Odin upside down with his right leg tucked beneath his left, just like AW's legs. Holder's painting also featured a red Fehu rune. See, at this point, I'm just upset that this guy is this bad at getting away with crimes. Like, what are you doing? I'm not even like on the part of the wrong guy being convicted. I'm on Holder now. How are you this bad at getting... Like, he's terrible at getting away with crimes, and he got away with the crime. Okay. Officers continue to find other social media postings from Holder that mimic the crime scene, but law enforcement declined to interview Holder again. Pagans finally reevaluated. Once the state charged Allen, his defense team insisted that Holder and Westfall receive another look. When law enforcement re-examined Holder, he changed the story about knowing AW. Back in 2017, he told law enforcement he never actually met AW. But in August of 23, he told law enforcement he met AW once. And during a deposition in 2024, he said he met AW 2 times. I mean, at least one of those encounters occurred shortly before AW's murder. Wait till you see his videos mocking people for thinking he could be involved. Oh, man. I hope he gets charged just so his lawyer has to feel that pain. At the insistence of Allen's counsel, they examined the alibi. Westfall's son, who was a minor when the murders occurred, could not remember if he was home with his dad when the girls went missing. I thought the son was the one that was in school, right? This time, law enforcement collected Westfall's phone, but he deleted data before turning it over, as innocent people do. He owns the Irish hat. Does he have a craving for honey? Holder's son. Okay. Got it. On the 4th, Allen's counsel deposed Case. The Liberty landfill, right? Remember that. Liberty Landfill is operating 2 staggered overlapping shifts. In a second goes missing. Scheduled to work from 5 to 1:30, but his badge swiped out during the second shift around 2:45. Holder did not have sole custody of his badge. His badge was on a public rack outside the view of cameras and accessible to other employees, including second shift. There's no lock on the badges, and Holder's name was prominent on his badge. If someone left when they were supposed to, but someone else clocked that person out an hour or so later, would that be known? I mean, nobody's ever clocked out for a coworker. That never happens. When the state moved to exclude any reference to the state's investigation into third parties, the trial court held a hearing on the motion. That's not a thing. How do you file a motion to exclude references to the investigation? I'm impressed they even thought of that. I married a coworker once. Only once. Yeah, have you heard of that, Aaron? A motion to exclude what you did? Like, how do you even, define the scope of that to put it into a motion? Yeah, okay. Okay. The judge sent them an email suggesting it. It's creative. Okay. At the hearing, Holder's wife testified that in 2018, Holder told her he had a fight with Westfall because Westfall wanted to up from animal slaughter to a different type of sacrifice. She also testified that Holder claimed that Westfall killed AW with others and that she needed to keep her mouth shut about it. She said no third parties had any connection to the crime. See, that's the thing. It's not, when we say third parties, never mind. That's just, I can't make that rant coherent. There's a guy that, the aforementioned habeas thing, this is more evidence than was presented in his entire case. And he's been in prison for 19 years. Okay. Summary of argument. Unconstitutional search. The trial court committed reversible error by admitting evidence seized under an unconstitutional warrant and by denying Allen a Franks hearing. Detective Liggett obtained the warrant for Allen's home only by omitting and altering witness descriptions to connect Allen to Bridge Guy and by misrepresenting that Allen admitted he wore a blue Carhartt like Bridge Guy. These misrepresentations and omissions misled the judge into believing multiple witnesses saw Allen in his car when in fact they described someone else and a different car. See, the drawing of the car in question, remember, it's this. This is the car that was described, of course. This is a perfect recreation of the car that was described by, hold on, let me check my notes here. Was it Wilson or Blair? I don't know. Anyway. Once the affidavit is corrected, there is no probable cause. Unprecedented confinement. Blair. Allen's confessions were involuntary and the product of grave mental disability caused by 13 months of maximum security pretrial solitary confinement, which exceeded IDOC policy and caused psychosis, paranoia, and confusion, while state actors were indifferent to his deterioration. Admission of these statements violated both federal due process and Indiana's protections against unnecessary rigor? That's such a weird word. State constitutions are crazy. Hold on, I gotta pull this up real quick. Indiana Constitution. Section. No person arrested or confined in jail shall be treated with unnecessary rigor. Okay. Unfair trial. Okay, so unprecedented confinement. Unfair trial. The trial court denied Allen his constitutional right to a fair trial through a series of arbitrary and prejudicial rulings that crippled his ability to present a complete defense. The trial court excluded critical exculpatory evidence, including Blair's sketch, which directly undermined... Wait, no. Not Luigi. Yeah, Luigi. Which directly undermined the state's eyewitness theory and timeline, and barred expert testimony challenging the reliability of the state's forensic methodology. It permitted inadmissible hearsay to rehabilitate the prosecution's timeline, and it blocked Allen from presenting evidence that showed the circumstances that led to his confessions and impeached their credibility, including audio depicting his deteriorated mental state. The court further prevented Allen from introducing substantial evidence of third-party guilt and an incomplete investigation, depriving the jury of context necessary to assess reasonable doubt. Collectively, these errors violated Allen's 14th and 6th Amendment rights and created a fundamentally one-sided proceeding. A new trial is constitutionally required to restore the integrity of the adversarial process. I'm pretty sure the Franks is in the appendix. If it's cited, I'm sure they'll take a look at it. Sorry, I just read something from Kat that I'm just trying not to derail myself right now. What in the Nancy Grace? I am seeking assistance with the preparation of my brief. Oh, thanks, Chuck. If anyone is available to help, I would appreciate it. And DM me. Okay, so one concern that I had with the brief is the enumerated errors are kind of sprawling, I guess is the word. I don't necessarily know that they're wrong or anything, but they're a little general. So one of the things I'm interested in is seeing if they can distill the argument or the error to a single decision for the court. What are they asking the court to say yes to, as opposed to just, oh, this is really messed up. What is the specific ask? Okay. Let's see. When reviewing the admission, they want the... Hold on a second. I need to hide my screen for a second. So you're just gonna have to look at this for a second. I need to make sure I don't have any notes on this thing I'm going to show. Nope, can't show it. Oh, well. Come back to it now. All right. Okay. Trial court committed reversible error by admitting evidence seized from the unconstitutional search of Alan's home and denying a Franks hearing. I had to contact my bank. Evidently, someone tried to use my card to call an Uber at 4:30 a.m. I'm sorry about that. When reviewing the admission of evidence after denial of a motion to suppress, the court considers evidence favorable to the ruling and uncontradicted evidence to the contrary. Fox versus State. Factual findings are reviewed for clear error, but the constitutionality of a search is de novo. Okay. One thing appeals can hang their hat on is where pretrial detainees can and cannot be held. This would be a way to prevent in the future when other county jails were available. Yeah. There are trade-offs to that, though. Sometimes prisons are significantly better than jails, but it depends, case-by-case thing. Allen filed a motion to suppress, motion for Franks hearing, amended request, and a lengthy memorandum with exhibits. The trial court denied the motion. Hearing, concluding Liggett's affidavit did not include false statements or omit facts with reckless disregard or intent to mislead. So mostly going to be clear error, it sounds like. The trial court erred by concluding Liggett did not make false statements or reckless omissions in his affidavit. Okay. Both the state and U.S. Constitution, prisons are not set up for attorney-client meetings, plus it's a case-by-case basis. Some are. A Franks hearing relates to the constitutionality and sufficiency of probable cause for a search warrant. Basically, if you make a sort of preliminary showing that there's a lack of probable cause due to misconduct or misrepresentation of the facts, then the state needs to show that the warrant was sufficient. Okay, the state must include all material facts in warrant application, including facts that cast doubt on the existence of probable cause and a source's reliability. A warrant is invalid if the police omitted facts with the intent to make the affidavit misleading or with reckless disregard for whether it would be misleading. And 2, the affidavit supplemented with the omitted information would have been insufficient to support a finding of probable cause. The defendant must prove a reckless or deliberate false statement by a preponderance of the evidence, so just more likely than not, 51%. An officer omits evidence with reckless disregard if the officer withholds a fact in his ken that any reasonable person would have known that the judge would wish to know. Examples include facts undermining the type of drug seized or in informant's reliability. This includes details undermining an officer's conclusion. Marijuana field officer described as near defendant's house was 2 to 6 miles away. USA versus Hernandez, 9th Circuit. Detective misled court by incorrectly reporting witness's description of suspect, equating description with defendant. Detective Liggett omitted and changed key information that undermined his conclusion Allen was bridge guy. Liggett misled the court in 4 ways. So, I'm not going to read the enumeration of error again. Reversible error by admitting evidence. Contradicts evidence to the contrary. Factual errors. Okay. misled the court to believe Blair's description of the man on the bridge matched Allen when it did not. Liggett told the court that Blair said the man was standing on the platform wearing a blue jacket and jeans, but Liggett omitted the rest of Blair's description that did not match Allen. The man had brown poofy hair, like the sketch below, was in his 20s or early 30s, youthful and medium build. Second, Liggett misled the court that Allen's car was parked. Exactly. At the old CPS lot during the time of the kidnappings. Detective Liggett told the court that after Blair saw the man on the bridge, she saw two girls she thought were AW and LG on the trail approaching the bridge. We have a barking objection. It's actually a speaking objection. Oh my goodness. Okay, misled the court. Allen's car was parked at the old CPS lot. Told the court that after Blair saw the man on the bridge, she saw two girls she thought were AW and LG on the trail. As Blair was leaving the trail, she saw a car oddly parked at the old CPS lot. Around 2:10, another witness, Wilson, also saw a car back in the CPS lot as if concealing the license plate. Both witnesses drew diagrams of the car parked in the same general area and manner. Oh, there it is. Liggett told the court that Allen parked his black 2016 Ford Focus at the old CPS building, but omitted that Blair said the car she saw during the time frame of the kidnapping was not black and had sharp angles like the sketch below. Considering the omitted information, Blair excluded Allen's black hatchback. I'm not from Detroit. I know that. Oh my goodness. Okay, this is a material omission. Seems fair. Third, Liggett misled the court that the man walking on 300 North was Bridge Guy. It's going to be about the carbo and the change of jacket color, I'm guessing. Liggett falsely told the court the carbo claimed the man was muddy and bloody wearing a blue jacket, when she actually said his jacket was tan and he was muddy. A bloody man in a blue jacket matches Bridge Guy. Maybe. A muddy man in a tan jacket does not. It's like a Dr. Seuss. But, like, very, a little bit more, graphic. Bloody man in a blue jacket. Muddy man in a tan jacket. Cruddy man in a red jacket. Fuddy-duddy in a green jacket. Okay. Liggett also admitted that Blair told him the man she saw on the bridge was not the same person Carbo described. ISP even released a public statement that the men are not the same person. They did. I remember that. Fourth, Liggett connected Allen to Bridge Guy by falsely claiming Allen admitted wearing a black or blue Carhartt and a head covering. The man the four girls saw wore the same clothes. Right. The clothes Allen admitted he wore matched the clothes by the individual on the bridge. Right? But Allen told investigators he did not know what he was wearing. Although Liggett used Allen's wife's statement that Allen currently owed a blue Carhartt as a nexus to his home, Liggett omitted that she said he purchased his coat a couple of years ago. Right. Makes sense. Had the court known Allen simply admitted owning a blue or a black coat, as does probably every 50-year-old man, it would have known there was no connection between him and Bridge Guy. Detective Lake's omissions and false statements recklessly misled the judge. And a reasonable person would have known the judge would wish to know that Blair's description of Bridge Guy in the car at CPS did not match Allen or his car, Carbo, tan versus blue, bloody versus muddy. Blair did not believe she saw the same man Carbo saw. Allen never said he bought a blue Carhartt or a head covering. And he bought his blue Carhartt a couple of years before 2022. The omitted and false information strikes at the heart of Liggett's conclusion that Allen was the man on LG's phone. The state's probable cause relies on a tight timeline, making Allen the man the four girls saw on the trail. Blair saw on the bridge and Carbo saw on the road. Any judge would want to... Let's not go crazy. I don't want any judge. Any judge would want to know if witnesses describe someone other than Allen, his car, or Bridge Guy. Moreover, the fact Liggett lied twice in the affidavit about the connection between Allen and Bridge Guy shows more than a reckless disregard for the truth. These falsehoods were directed at connecting Allen to LG's video, which would otherwise include any white male. With the omitted and accurate evidence, the affidavit was insufficient to establish probable cause. Probable cause exists when there is sufficient evidence to cause a reasonably prudent person to believe a search will uncover evidence of a crime. Is that the right standard? Probable cause and sufficient evidence. Okay. A reasonably prudent person would not believe Allen was connected to the murders or that evidence would be found in his home. The state is left with Dullen's report claiming Allen told him he was on the trails between 1:30 and 3:30 and saw three girls, not four girls, like those who thought they saw Bridge Guy. Okay. During his October 13, 2022 interview, Allen admitted wearing blue jeans and owning a gun, knives, and a blue or black jacket, and walking out to the first platform of the bridge to watch fish. But Allen does not look anything like the person Blair saw on the bridge, although his car is a different color and shape than the oddly parked car. And the man Carbo saw walking was most likely not even Bridge Guy. They literally know the man who's sacrificing animals with the same Norse runes made out of sticks. The reason guilters fall back under the clothing thing is because there's no evidence against Allen. Is that like their main argument that the clothing? That's not very good. Nobody would ever get convicted based on the color of their clothing. If Allen being on the trail within the same 2 hours the girls were abducted is enough for a warrant, law enforcement would have obtained one for Allen's home in 2017. Damn, Boogie's being a little shady there, painting with kind of a broad brush, huh? Nothing about his pants, so I can't... Exactly, Garnett. 2022, internet service provider had no more evidence connecting Allen to the murders than they had days after the murders when Allen, like others, responded to their request for help. I really been shady. We're going to get along. It was not enough then, and it was not enough in 2022. The error requires reversal. Based on this, courts love the path of least resistance. I could see just remanding for a Franks hearing. Kick the can down the road. It's a Court of Appeals' favorite thing to do. Speaking of, let me just check gaappeals.us. Let's check today's opinions. Yep, they love kicking the cans down the road. Okay. Court must suppress fruits of an illegal search. 1963. The state's entire case is built on Liggett's half-truths and falsehoods. Isn't this just one of their arguments? Yes, but courts of appeals don't like deciding things if they don't have to. So if you give them an out and an opportunity to kick things back down on the narrowest grounds possible without resolving anything and hoping that their problem goes away, that's very often what they'll do. I have an appeal right now where we're arguing that there were problems with the guilty plea, there were problems with the withdrawal of the guilty plea, with sentencing and all this stuff, the knowing and willfulness of the guilty plea. But instead of grappling with that, I think the court could just, again, similar to this case, kick it back down for a hearing on essentially the same issue we're asking the Court of Appeals to decide, which is probably the most likely outcome. So yeah, it's entirely possible that the Court of Appeals will kick it down for a Franks hearing. Then there's a Franks hearing, and then that gets appealed back up, and we're back in the same place. But the next argument would then be, if you think they were PC. Yes. I mean, they could decide that, no question. Okay, the state's entire case is built on Liggett's half-truths and falsehoods without the gun seized in the search. There is no opinion from Oberg upon which the state arrested Allen. True. And without the arrests, there are no confessions. I think, is there an independent source doctrine? I don't think so. If the warrant was illegal, the state has no case. You guys see everything. Even if this court finds the confession was not a product of solitary, Allen is still entitled to a new trial. Before a constitutional error can be held harmless, the court must find it's harmless beyond a reasonable doubt. Without the fruits of the search, the gun, a casing, and a hope box, the Carhartt knives and computer, the state cannot prove the jury would have convicted. Yeah, exactly, Aaron. I don't know why you know that better than I do. But yeah, if they find one error that they can reverse on, they will. They'll always say, because we reverse on this ground, we decline to reach errors 1 in 3 through 15. At minimum, Allen is entitled to remand for a Franks hearing. So this is probably if there's relief, this is probably the one. Even if Allen's exhibits to the Franks motion did not prove by a preponderance that Liggett deliberately or recklessly falsified or omitted material information, they entitled him to a hearing. A defendant who makes a substantial preliminary showing that, and somebody was asking what a Franks hearing is, that's this part, showing that an affidavit included a false statement or reckless omission necessary to probable cause. Affidavit included a false statement or reckless omission necessary but to establish probable cause, is constitutionally entitled to challenge the warrant at a hearing. To meet the showing, the defendant need not present conclusive proof, but must support their accusations with evidence and citations to the warrant application. Here, the court's denial of a hearing was legally erroneous because Allen made a substantial showing. Allen supported his claims with depositions, police interviews, and reports. Citing Liggett's application, Allen made specific arguments. In a final motion, Allen reiterated these points, urging the court to compare the affidavit with Blair's and Carbo's interviews. Telling the trial court was willing to schedule a Franks hearing when Allen was represented by Fort Wayne attorneys, but refused when the original attorneys were reinstated. Allen's constitutional protections are not contingent on who his attorneys are. That's true. So yeah, I could see that working. Who argues this Franks hearing? It could be either, I guess. Whoever Allen wants. A Mandela quote. Nice touch. Solitary confinement is a form of punishment and, depending on its conditions, even torture. By 2023, when Allen was held in solitary for 13 months, it was well established that prolonged isolation causes psychological pain, suicidal ideation, and psychosis. To protect inmates from psychological harm, the IDOC strictly prohibits solitary confinement over 30 days for anyone with a serious mental illness and requires transfer if SMI symptoms appear. If it would be in front of Gull, why bother? I don't know. When Allen exhibited the predictable symptoms of psychological pain, confusion, and psychosis, IDOC administrators refused to transfer him to a mental health unit. When Allen's attorneys informed the court of his dire condition, the court also refused to move him, and the prosecutor delayed and mocked counsel's concerns while collecting evidence of Allen's confessions. The question for this court is unprecedented but simple. Should the state be able to benefit from Allen's psychological pain that their deliberate indifference to his mental health caused? Human decency provides the answer no. Can they get the judge switched out by any means? I assume there's some kind of motion to disqualify, but I don't know Indiana procedure. An appellate court reviews a suppression denial for substantial evidence of probative value that supports the trial court's decision. Considers uncontradicted evidence favorable to the defendant and reviews legal issues de novo. The voluntariness of a confession is a legal issue. Allen moved to suppress his statements made while in solitary confinement, which the court denied. The court reasoned the statements were voluntary because Allen failed to show they resulted from state psychological coercion or coercive interrogation. There's actually a case I was looking at recently that is similar to this. What was the name? Jenkins? No. Maybe it was. I'm gonna have to come back to this. I thought I had it marked. Nope, not this one. Malcolm, maybe? No. Lawrence Appeal, Jenkins. Graham? I'm gonna have to come back to this, I think. It was similar. There's a case where somebody was interrogated on somebody had been shot and they were in a hospital bed. They had just had, I think, their spleen removed and parts of their other organs removed, and they were on fentanyl and another painkiller. And an officer came in and interrogated them. And the admission of the confession was upheld because it wasn't coercive, apparently. It's driving me crazy. I specifically had this case like labeled just so I could use this later, but whatever. Okay. Allen moved to suppress his statements made while in solitary confinement, which the court denied. They're voluntary because he failed to show how they resulted from state's coercion or coercive interrogation. I wish I could find that case. It's pretty much directly on point. The court found Allen's detention was intended to protect him, and that while he suffered from MDD and anxiety, he did not have SMI that would render his statements involuntary. In addition to IDOC records and videos like those in a trial, Allen proffered an order in settlement from Indiana Protective Agencies versus IDOC that the trial court excluded from the suppression hearing as irrelevant. In 2011, the Southern District of Indiana held that IDOC's housing of SMI inmates in solitary constituted cruel and unusual punishment, violating the Eighth Amendment. The Southern District found SMI includes delusional disorder, psychotic disorder, and MDD. Segregation is harmful. Inmate decompensating. Before a hearing on relief, the parties reached a settlement, including expanded definition of SMI. The IDOC policies refer to the settlement, which sets the policy's tone. This is a tough argument to win. An inmate with SMI can only be held in solitary 30 days. If an inmate decompensates into SMI and is unlikely to return to Gen Pop within 30 days, transfer is required. Allen admitted Dr. Westcott's 127-page report. On August 21st, 23, Westcott evaluated Allen, who had been in WCU over 9 months. He was terrified, unsure it was real, and wondering if he was dead, in hell, or waiting for heaven. He could not recall weeks of early 23. He believed he had been drugged. Westcott cited IDOC records showing acute periods of confusion, delusion, cognitive slowing. During this period of loss of touch with reality, Allen confessed. Westcott concluded Allen's psychosis stemmed from MDD, his personality, and the well-known effects of solitary. Trial court abused its discretion by refusing to admit the order of settlement into the suppression hearing. Okay. Evidence is relevant if it has any tendency to make a fact of consequence in determining the action more or less probable. Here, the order of settlement makes it more likely Allen's psychosis was caused by his confinement? I don't know if I buy that exactly. It seems like the order of settlement had more to do with the finding of a separate court and policies of IDOC. But we'll see. The order found solitary confinement causes all the symptoms Allen experienced. Allen was more likely to decompensate because he spent 7 months on suicide watch, an even more restrictive form of solitary. The order of settlement also makes it more likely Allen was subjected to psychological coercion by showing solitary causes psychological pain. It demonstrates state action, true. The IDOC placing and keeping Allen solitary, knowing it was causing this predictable pain. The order of settlement shows how extensively IDOC violated its own policy. True. That's a better argument. As it included MDD in the SMI definition, restricting Allen solitary to 30 days. Did I miss it? I did miss it. You're right. If Brad Holder was charged, the state would say he asked someone to collect cover for him to create a false alibi. Yeah. No, wait, Nick can't hear me. Okay, so policy. Allen was harmed by the court's refusal to consider the order of settlement because it undermined the court's findings and conclusions. The state failed to prove Allen's statements made while gravely disabled were voluntary. An involuntary statement obtained through state action violates due process. A confession is voluntary if it is a product of rational intellect and freely self-determined rather than overborne will by state law enforcement conduct. State law enforcement can include psychiatric facilities and prison staff. Statements produced through a coercive environment are involuntary regardless of whether solicited through police interrogation. I'm guessing the other argument's going to be about what produced through means. What produced through means? Like, is it enough to just be in a coercive environment? Like, if you're in a coercive environment, everything's involuntary? Guess so, because that's what this case stands for. Let me see. Staff at psychiatric facility created a coercive environment, rendering a juvenile's confessions involuntary. The crucial element is police overreaching. When state actors use more subtle forms of psychological coercion, the defendant's mental illness is more significant in the voluntariness determination. But the state must still exploit the defendant's illness with coercive tactics. This is generally done through aggressive interrogation, but exploitation can occur in other ways. A truth serum case. That sounds interesting. For a statement to be involuntary, state action must be causally related to the confession. The state's prolonged solitary confinement of Allen was state action. Of course. Prolonged maximum security solitary confinement of a pretrial detainee, especially after psychosis develops, is state action. No disputing that. Unlike the mentally ill defendant in Connolly who walked into a police station and confessed, Allen never voluntarily came into custody. He consistently protested innocence until enduring 5 months of maximum security solitary with no human conduct except while chained or caged. Because it was pretrial, Allen's solitary was unprecedented and borderline, if not unconstitutional punishment. Other IDOC safekeepers were in mental health units, not solitary. On a continuum of possible punishments in the justice system, solitary confinement in a maximum security facility is the most extreme. Also, the solitary exceeded the 30-day IDOC policy restriction. IDOC knew it could harm Allen. Keeping an Allen solitary when he was no doubt SMI was an administrative, not clinical decision. Finally, the state's conduct also involved the prosecutor, law enforcement, and the court. After Allen filed his April 5 emergency transfer motion citing his dire condition, the prosecutor waited 9 days to respond while investigators monitored real-time calls in which Allen confessed. During this delay, Allen continued deteriorating. The prosecutor then mocked defense concerns as colorful and dramatic, while that same day IDOC found Allen gravely disabled. Nick said, I have a theory that Brad was an informant prior to this case. Yeah, that makes a lot of sense. Knowing Allen was decompensating, the court refused to transfer him, putting the onus on IDOC to provide care. What in the name of God? It got very loud out here. One week later, the prosecutor sought all medical records, videos, and communications while confessions were ongoing. Monitoring and collecting his statements consumed hundreds of hours and produced over 60 confessions. ISP interviewed inmates and guards and even sent a psychologist to speak with Dr. Walla. Allen showed more than sufficient state action. The state's prolonged pretrial solitary confinement was psychological coercion. I see this. Allen's, solitary with psychological coercion was prolonged, caused psychological pain, and put him at the mercy of the state. The prolonged nature is coercion because solitary confinement can bring a person to the edge of madness, perhaps to madness itself. This has been recognized in literature, law, and science. Trauma. From day one at WCU, Allen was placed in a strip cell, the most restrictive cell in the most restrictive solitary unit, with only bare essentials and a camera constantly recording him. Soon thereafter, IDOC ordered guards to videotape him when out of the cell, including showering and attorney visits. Suicide companions remained outside his door, documenting everything, regardless of suicide watch status. He had no contact with anyone unless caged or chained. The sensory deprivation, social isolation, and forced idleness is difficult even for healthy people. I don't know, man. They really are. Stop. Okay, there we go. Don't do it again. Early videos show Allen pacing his 8.5 by 12.5 cell, laying down, doing leg crunches, writing, reading, and looking distressed. Within 2 weeks, Allen said he was broken and told his wife, if this becomes too much for you to call detectives, and I will tell them whatever they want to know. Had Allen's solitary been 30 or even 90 days, he would not have been decompensated, but it was 13 months. The prolonged solitary caused Allen predictable psychological pain, paranoia, nightmares, memory problems, and confusion. It is undisputed Allen deteriorated to being gravely disabled and very psychotic, and the IDOC involuntary administered antipsychotics between April and late June. Although Walla noted concerns about fainting, she diagnosed psychosis and suspected incompetence and over-medication. Someone investigating a crime outside your house, I actually think they're using leaf blowers to look for evidence. That's what you do, you know? It's very genius. It's a genius way to look for evidence. So you have like a bunch of evidence in one place, and you just blow it around, and that way you'll be able to see it when it moves around. There it is. There it is. I think they might have found something. I'm so annoyed right now. Okay. Sanding? It could be. Although Walla noted concerns about fainting, she diagnosed psychosis and suspected incompetence over medication. I read that. And WCU only monitored Allen's mental health. Talking with a psychologist while shackled in a cage is not treatment. Solitary put Allen in a constant state of vulnerability. Solitary confinement has long been recognized as psychologically coercive, equal to the rack, the thumbscrew, and protracted questioning. Pretrial solitary is punishment already underway and conveys, without necessity of spoken words, the implied threat of further punishment. It does not matter whether the defendant was in solitary, whether justified, or whether the prison planned further punishment. I could kill somebody right now. In this harsh environment, Dr. Walla controlled all aspects of Allen's life, including whether he got bedding, clothes, meal items, books, personal items, and utensils. She could provide a new window and a tablet, or strip him to bare necessities. Privileges were contingent on pleasing her. Whether Walla had ill intent is irrelevant, is what Allen thought and what solitary confinement did to him, or were due to many of us. After confessing to Walla on May 3, he asked for his property back, and she indicated she needed more consistency. Wood dust does smell good. Allen's confessions were a product of solitary-induced psychosis, not rational intellect. IDOC records show that Allen continued to suffer from psychotic episodes, probably, during the time he confessed. On April 5, when he confessed to Dr. Walla, he was not eating or sleeping and was drinking from the toilet. On May 3, when he confessed, Allen had symptoms of paranoia and disorientation, despite Walla claiming he presented as more organized than he had been. The day before, he was confusing nightmares with reality and claiming to have started World War III. 2 days before, he was too disjointed to hold a conversation. Days earlier, he covered himself in feces and claimed he was King Michael. His confessions to guards occurred during bizarre and psychotic behavior. Guards believed he was faking, but they're not clinicians, and Dr. Westcott found no malingering through objective testing. Allen confessed to his family repeatedly. On April 3rd, he fell on the floor, asked if he was dead and suicidal. On May 10th, he believed he was dead. The world would blow up if he slept, his water was poisoned, and he was reliving the same day. On May 25th, he paced for 2 hours and banged his head. On June 11th, he thought he was in hell and did not understand what was happening. State action overbore Allen's will. Allen did not confess until after 5 to 7 months of solitary. Before arrest, he consistently denied involvement. Dr. Westcott opined Allen's psychosis was caused by the stress of solitary confinement on pre-existing illness. Dr. Waller agreed that a lot of the time solitary confinement exacerbates mental illness, and it is reasonable to believe Allen's confinement caused the psychosis. The social isolation of solitary makes people question their self. If you are treated like you are guilty, you begin to think you are. Dr. Grassian testified a false memory starts with a belief. In his first confession to his wife, Allen said, "I think I did it." In his first confession to Dr. Waller, he was unsure if he had sex with the girls. Allen got facts wrong and confessed to crimes he did not commit. Okay. Indiana Constitution also protects against the admission of involuntary statements. Indiana's test is like the due process standard, requiring a confession be freely self-determined by a rational intellect and free will. Yeah, this sounds like a better standard. He could have satisfied the federal standard, but this seems like a more favorable standard, just the phrasing of it. Rational intellect specifically. However, it's more robust because it requires the state to prove voluntariness beyond a reasonable doubt. Also, it does not require state action be coercive to overcome a mentally ill person's will. But mental illness alone will not render a statement involuntary. There must be some state negligence that contributed to overcoming the defendant's rational intellect. Here, the IDOC's refusal to apply their 30-day policy to Allen and to transfer him after he deteriorated is at minimum negligent state conduct that caused Allen's psychosis and confessions. And the prosecutor's delay in the trial court's refusal to set a timely hearing exacerbated the deterioration. This is conduct that our Constitution cannot tolerate, regardless of whether it constitutes coercion under federal due process. Agreed? Also, the evidence does not show the statements were a product of rational intellect beyond a reasonable doubt. Allen was considered gravely disabled through June 16th, when he received his last emergency injection due to self-harm. Although Wallace sometimes described Allen as more coherent or his symptoms not significant, the state cannot have it both ways, i.e. Allen decompensated to the point of forced medication, but remained rational beyond a reasonable doubt. Even if Allen could occasionally hold a conversation, it does not render his confession voluntary. Okay, even if the court finds the statements voluntary, they are a product of unconstitutional detention. Violate 12 and 15. Indiana courts are constitutionally bound by the basic concepts of fairness that are frequently identified with due process in the federal Constitution. Article 12 guarantees for every person, for every injury done to him in his person, remedy by due course of law. Here, Allen was sent to solitary for safekeeping without even a hearing or notice. Even when his attorneys informed the court of his dire condition, the court refused to set a hearing in violation of this very long code section. Although the court eventually held a hearing on June 15th, by that time the damage was done. Fairness protections in criminal cases are found in different Indiana constitutional provisions. Just as pretrial punishment violates federal due process, it violates the Indiana Constitution. Indiana is one of just 6 states protecting citizens from unnecessary rigor. The framers wrote, "No person arrested or confined in jail shall be treated with unnecessary rigor. Typically, this provision requires a prisoner suffers severe mistreatment." Why does it require Prisoners suffer severe mistreatment? Strange. Okay, recognizing this provision applies to solitary confinement, the Indiana Supreme Court stated the very essence of punishment and the sole use of the prison walls is the confinement of the convict within them. Humanity indeed forbids as unnecessary rigor that his confinement should be absolute solitary, that all of his natural and civil rights should be temporarily annihilated. Here, Allen's treatment rose to the level of unnecessary rigor. Rigor is the act or instance of strictness, severity, or cruelty. When Allen started suffering from confusion, memory lapses, paranoia, and bizarre behaviors, there was no longer a risk he could not handle the harsh conditions. It was a reality. The strictness, severity, and cruelty of his confinement is evident on video, where he is screaming in fear, confused about where he is, unable to respond, and drooling and self-harming. The rigor was physical too. Allen lost 40 pounds, was unable to care for himself, was tased, his face was black and blue, and at times bleeding, and he was poisoned by fecal matter and toilet water. Indifference to his catatonia is shown where medical staff discussed blood pressure and cholesterol with a vacant Allen. This psychological and physical pain was unnecessary. IDOC could have transferred him upon deterioration as policy requires. Even an isolated infirmary cell would have been better than the whole designed for punishment. Likewise, the court could have moved him when the court learned of his dire condition. The constitutional violations require suppression. This is interesting with the remedy question. Over 150 years ago, Dostoevsky wrote, "The degree of civilization in society can be judged by entering its prisons." In 2015, writing about the effects of solitary, Justice Kennedy hearkened to this quote, noting there is truth to this in our own time. Applying the exclusionary rule to these constitutional violations would deter abuses within our prison system and law enforcement, protect judicial system integrity by showing condemn such conduct, and protect the human dignity of those unable to make bond. Interesting. Indiana has a robust exclusionary rule. Relying on Article 1, Indiana adopted the exclusionary rule long before the Fourth Amendment exclusionary rule applied to the states. Under the exclusionary rule, to determine whether a statement is a product of an illegal detention, the court must ask if the statement has been come at by exploitation of that illegality or instead by means sufficiently distinguishable to be purged of the primary taint. The court considers the time elapsed between the illegality and the acquisition of the evidence, the presence of intervening circumstances, and the purpose and flagrancy of the misconduct. First, the statements occurred during the illegality. There were no intervening circumstances, a well-known connection between solitary and psychosis. Third, the violation was flagrant because IDOC violated its own policies. Good argument. A simple argument. Gall expressed outright loathing for Allen when she said she didn't want him in her chambers. She sounds lovely. Even if this court finds Allen's statements were voluntary because he was not interrogated by law enforcement, he was still gravely disabled when he confessed. As such, his free will did not purge the taint of his illegal detention. A trial court erred by denying the motion to suppress. The error was not harmless. Before federal or state constitutional error can be held harmless, the court must find it harmful beyond a reasonable doubt. No piece of evidence may have greater sway over a jury than a defendant's confession. The erroneous submissions of statements to Dr. Walla alone was prejudicial because they were a large part of the state's case. The prosecutor particularly concentrated on Allen's May 3 statement, arguing that Allen knew a fact only the killer would know. The confessions also countered Allen's confident and unwavering pre-solitary protest of innocence. Let me see. The court denied Allen his right to present a complete defense, to explain the scene and impeach the investigation. The 14th Amendment guarantees a defendant the right to a fair trial. The Due Process Clause places significant substantive limits on state power, prohibiting its arbitrary exertion and guaranteeing criminal defendants a fair opportunity to defend against the accusations. For an opportunity to be fair, the defendant must be permitted to confront and cross-examine witnesses and to call witnesses in his or her own behalf. These overarching principles operate in tandem with the Sixth Amendment, which similarly guarantees criminal defendants a meaningful opportunity to present a complete defense. Although trial courts have broad discretion in conducting trials, this discretion has constitutional limits. That is, courts may not infringe upon a weighty interest of the accused through decisions that are arbitrary or disproportionate to the purposes they are designed to serve. As explained more fully below, the trial court made several reversible errors under the rules of evidence and Indiana's trial rules. In many instances, these decisions violated the Constitution as well. While this court assesses claims relating to admitting or excluding evidence for abuse of discretion, to the extent those claims implicate constitutional issues, de novo review. Errors in the admission of evidence will be disregarded as harmless if its probable impact on the jury is sufficiently minor so as not to affect the substantial rights of the parties. But when the error is constitutional, the standard is higher. Again, this is similar to the prior standard. Generally, before federal constitutional error can be held harmless, the court must be able to declare a belief that it was harmless beyond a reasonable doubt. Hey, Nick. Starting to lose my voice. At trial, the court prohibited Allen from using Blair's sketch of Bridge Guy. This decision violated our rules of evidence and denied Allen his constitutional right to present a defense of mistaken identity. Evidence is relevant when it has a tendency, we just read that a second ago. A court may exclude relevant evidence if its probative value is, Rule 403, substantially outweighed by a danger of unfair prejudice, being confusing the issues, undue delay, accumulative. Blair's sketch proves she did not see Allen on the bridge. You have to come on here more often so you can be used to... Seriously. Oh, man. I'm out of shape. She did not identify... Blair's sketch proves she did not see Allen on the bridge. Blair did not identify Allen in court as Bridge Guy. But according to the prosecutor, Blair must have seen Allen on the bridge because Allen told us he went onto the Mountain High Bridge out to the first platform, which is exactly where Blair saw Bridge Guy. Okay. How many times do I have to look at Luigi? Okay. Blair's sketch shows Allen looking nothing like the person Blair saw. Just 3 days after the murders, Blair met with the sketch artist and described the man she saw on the bridge as white. About 20, of medium build, and having brown curly hair. I believe it was poofy hair. An artist created the following sketch based on Blair's description. This looks nothing like Allen. At the time of the murders, Allen was a robust 5'6", 44 years old, with closely cropped hair. Blair's sketch also shows that she and Carbeau saw different people. The state's timeline for the murders is dependent upon Carbeau and Blair seeing the same person. The prosecutor told the jury that every eyewitness is adamant the person they saw was Bridge Guy. There's no doubt in their minds. But Blair's sketch disproves this claim. Carbeau, like Blair, made a sketch. When Blair saw it, she described it as wrong and not who she saw. Blair's sketch impeaches the investigation and shows law enforcement bias against Allen. For 2 years, law enforcement circulated Carbeau's sketch without it yielding a single arrest. So in April of 2019, ISP released Blair's sketch, declared it represented the face of Bridge Guy, and announced that Blair and Carbeau did not see the same person. After Allen's arrest, the story changed, and the jury was told Carbeau and Blair saw the same person. Blair's sketch was reliable and probative of Bridge Guy's identity. Blair contacted law enforcement the day the girls went missing, and it was very clear to her she saw Bridge Guy. 2 days later, she developed her sketch with an artist in a book of facial features. She rated her sketch 10 out of 10. In 2019, she met with law enforcement repeatedly. She reaffirmed her confidence in her sketch. She insisted that she could identify Bridge Guy if she saw him. Blair's sketch is not hearsay. That's what I was assuming they were going to get to this part. Yeah, after I get through this, after I finish reading this, I'm going to need to take a break. I just can't talk much longer, but I'll do probably a second stream where I actually do more of an analysis. I've kind of just gotten to reading it at this point. Let's see. Not hearsay. Bears the use of out-of-court statements for the truth of the matter asserted, unless the statement falls within an exception. Here, Blair's sketch was not a statement. Although Indiana has not reached the issue, other courts hold that a sketch is the functional equivalent of a photograph. No statement is involved. The sketch is not hearsay. A statement is not hearsay if the declarant testifies and is subject to cross about a prior statement, and the statement is an identification of a person shortly after perceiving the person. I forgot about that one. The rule applies regardless of whether the identifying witness makes a positive in-court identification or not. Here, Blair identified Bridge Guy to law enforcement immediately and developed her sketch 3 days later. Blair's sketch is also admissible as an adoptive admission. A statement is not hearsay when it's offered against an opposing party and is one the party manifested that it adopted or believed to be true. That occurred here. In April 2019, ISP released Blair's sketch to the public and declared, "This is the face of Bridge Guy." Oh, that's funny. That is a very adoptive admission. Blair's sketch is admissible under Indiana's common law, too. Decades before Indiana adopted the rules of evidence, sketches were admissible if the eyewitness took the stand at trial. Even if the sketch was inadmissible hearsay, Allen was still entitled to use it. State law does not have the last word on hearsay. The rule must yield to the constitutional right to present a defense. When identity is crucial to the case, a defendant is entitled to defend on a claim of mistaken identity. And this right cannot be abridged through the application of arbitrary or disproportionate rules or the mechanistic application of otherwise rational rules. Excluding the sketch violated the Constitution, here the state concedes that Bridge Guy's identity was crucial to the case. Blair's sketch was critical to Allen's defense of mistaken identity, and the judge's decision to exclude it was arbitrary and disproportionate to any legitimate government interest. Again, no harmless error. The error was harmful under both the constitutional and Indiana standards. No dispute that the state's timeline depended on Blair seeing Allen on the bridge and Blair and Carbeau seeing the same person. Blair's sketch disproved both points. Excluding it affected Allen's substantial rights and the verdict. The court committed reversible error in excluding Tobin's testimony. Allen tendered William Tobin to explain the scientific community's robust criticism of the AFTE's toolmark matching methodology. The judge excluded him because he was not a firearms expert, he was untrained in firearms identification, he did not examine the evidence in this case, and he did not conduct a firearms examination. According to Tobin's testimony does not go to an issue before the jury and lacks relevance. This decision violated our rules of evidence and violated Allen's constitutional right to present a defense. Expert testimony should be admitted if the expert is qualified, and the testimony will help the trier of fact to understand the evidence or to determine a fact in issue. The Indiana opted this rule to liberal. Okay, so the legislature wanted a more liberal expert admissibility standard. I can barely talk. Tobin was clearly qualified to explain the scientific community's robust criticism of the AFTE methodology. Tobin is a nationally recognized expert in forensic metallurgy and material science who has testified as an expert in many cases, over 297, involving the validity and reliability of firearms and tool marks. He has extensive experience in metallurgy, bullet and lead analysis, and tool mark principles, along with a background in statistics. Testimony was essential for assessing Oberg's credibility and determining what to believe. Once an expert takes the stand, their credibility is fair game for impeachment. The jury is ultimately responsible for assessing witness credibility and determining what to believe. Here, Oberg testified that she matched tool marks on test firings from Allen's gun with tool marks on the unspent cartridge found at the murder scene. Oberg told the jury she found agreement between the tool marks by using AFTE methodology. She gave an error rate of 2.2% for false positives and 2.8% for false negatives. She discussed studies and articles that she reviewed to apply the methodology. And over relevancy objections, she described studies relating to guns that were not even the P239. A lay juror might find this testimony impressive and coherent, but the methodology is anything but straightforward. Tobin's experience would help a jury understand the scientific community's criticism of AFTE's subjective methodology and force Oberg to engage with that critique. Even if our rules tolerated Tobin's exclusion, the decision was patently unconstitutional. A defendant is entitled to a meaningful opportunity to present a complete defense. This entitles him to impeach a witness who provides a crucial link in the proof of the defendant's guilt. Although trial courts possess broad discretion to limit impeachment, the discretion cannot be used to arbitrarily exclude competent, reliable evidence bearing on witness credibility when such evidence is central to the defendant's claim of innocence. Here, Oberg's credibility was central to the case, and the judge arbitrarily excluded Tobin. Tobin's is an expert in the AFT methodology and its shortcomings. He has experience with firearms identification, and he examined Oberg's materials. There's no legitimate state interest in excluding Tobin. Allen did not waive his right to appeal the Tobin issue by calling Warren. A party aggrieved by an erroneous evidentiary ruling is entitled to respond to the improper ruling without sacrificing the right to appellate recourse. Once the court excluded Tobin, Allen responded by calling Warren, who endorsed the use of the methodology and engaged Oberg in a battle of experts over how to properly apply the methodology to the evidence. This decision did not waive Allen's right to appeal Tobin's exclusion. Yeah, that sounds like a different challenge to Oberg. The validity of the method versus the application of the method. Makes perfect sense. The error was harmful. Again, same standard. The state told the jury Oberg's never been wrong. That's just insane. That Allen has no explanation of how his bullet from his gun ended up between the bodies of AW and LG. Had the jury heard Tobin's robust impeachment, the outcome of this case would probably be different. The court committed reversible error in admitting hearsay to rehabilitate the timeline. The state built its entire case upon the following timeline. Allen encountered the girls at 2:13. He completed the murders alone, left LG's phone at the murder scene, was spotted by Carbeau at 3:56, and never returned. If Allen committed the murders, there should be no human-initiated activity. Oh, this can be the Google stuff. There should be no human-initiated activity on LG's phone after 3:56. But there was. At trial, Allen called Eldridge, a former FBI forensic examiner, who examined the data from LG's phone and testified that wired headphones or an aux cable were plugged into the phone at 5:45 and then removed at 10:32. This action would silence a phone call. And she noted that the data showed an incoming call moments before the headphones were inserted, suggesting someone was intentionally silencing LG's phone. Since the state claimed Allen left the murder scene at 3:56, Eldridge evidence eviscerated the state's timeline and showed someone else committed the murders. The state responded by asking Cecil, its phone expert, whether water damage could simulate headphones being plugged into LG's phone. Over a hearsay objection, Cecil testified he Googled it and found some unspecified, non-peer-reviewed troubleshooting forums reporting that it could. Cecil's testimony was inadmissible totem pole hearsay. Unless our evidence rules provide otherwise, out-of-court statements are not admissible for their truth. For totem pole hearsay to be admissible, each part of the combined statements must conform with an exception to the rule. Never heard that called totem pole hearsay before, but I like that. Here, the posts on the troubleshooting forum are at least double hearsay. The internet forum and the statements posted there. Cecil's status as an expert does not affect the hearsay analysis. Statements contained in a reliable authority can be admitted over hearsay objection when used to contradict an expert who is testifying on the witness stand. But here, the online forum was neither reliable nor used to contradict Cecil. Rule 703 does not avail the state either. Under 703, experts may testify to opinions based on inadmissible evidence if the evidence is of the type reasonably relied upon by experts in the field. The rule, however, does not authorize experts to parrot facts that the expert adds nothing to. Cecil added nothing here. He was a mouthpiece for totem pole hearsay that he Googled. The error was unconstitutional. Here, the judge arbitrarily allowed the state to undermine Aldridge's testimony with a person's internet post, and it was impossible for Allen to impeach the person through cross-examination. Error was harmful. Testimony undermined the timeline upon which the state built its entire case. Allowing the state to rehabilitate the timeline affected Allen's substantial rights in the jury's decision. Let's see. Reversible error by excluding evidence that impeached the credibility of the confessions. At trial, Allen sought to impeach the credibility of his confessions. The judge made 3 reversible errors. That's a lot of reversible errors. Together, the decisions violated his constitutional right to present a defense. When a defendant confesses, the manner in which the confession was obtained is irrelevant to the confession's credibility. Whoa. The court erred by excluding the audio from Allen's solitary confinement videos. At trial, Allen moved to introduce 15 videos showing the conditions he endured in solitary confinement. The state sustained the state's hearsay objection and ordered Allen to mute the videos when he showed them to the jury. This was reversible error. The audio serves a delusional, confused, and disorganized mind. Yeah, I've been trying not to read too much from chat, but try to maintain the first run through. But it is helpful to have some of the context. Let me see. Accordingly, Allen respectfully requests that this court watch the videos with audio, especially these videos. We looked at those earlier. The statements in those videos are not hearsay. Statements are not hearsay when used to prove a defendant's state of mind. It's also just not offered for the truth. This was precisely Allen's purpose in offering the evidence, and the trial court conceded this. To the extent there are older cases suggesting that a defendant can never admit his own statements, those decisions are inconsistent with the adoption of the modern rules. The audio in this video is also relevant because it impeaches Dr. Wall's testimony and undermines her medical records. Wall's evidence gave the misleading impression that Allen provided organized and detailed confessions with a beginning, middle, and end, but the omitted audio rebuts this, showing a disorganized, nonsensical, and confused Allen. On May 3rd, for example, Walla describes Allen's mind as more organized than he'd been, but the April 28th video puts the statement in context, showing a disjointed, tangential, nonsensical, and rambling Allen. He is plainly psychotic and unreliable. The audio also presents a vivid picture of solitary confinement's harsh conditions. Staff talk callously to Allen. Guards remark how long feces is on his back. Inmates tell him to kill himself, and medical staff ignore obvious signs of SMI and overmedication. In one video, medical personnel ask Allen about his cholesterol and blood pressure while ignoring his catatonia and drool. Without the audio, this video presents a misleading impression that the medical professionals are attentive when in fact they are not. The error was harmful. The audio shows that Allen's statement in solitary confinement are unworthy of belief. Excluding them, therefore, affected his substantial rights and likely influenced the jury's decision. I like that argument. Reversible error in prohibiting the jury from hearing 2 phone calls he made on April 3rd. On April 2nd, he called his mother and discussed finding religion. In the early morning of the 3rd, he made 3 intertwined calls. Over objection, the jury heard the second call where Allen confessed to his wife, but the judge prohibited the jury from hearing the calls that bookended it, where Allen questioned his sanity and the veracity of his own statements. Trooper Harshman's testimony made the error worse. Over objection, Harshman claimed that, when confessing, Allen was consistently calm, subdued, and solemn, in tone showing no indication of duress or stress. But the excluded April 3rd calls discredit this testimony. This is almost like a rule of completeness. Allen was confused and forgetful. He believed he was losing his mind and that IDOC was poisoning him. He referred to being mentally tortured, comparing his environment to Guantanamo Bay. I don't know. Guantanamo Bay is probably better. Independently, this error was harmful and warrants reversal. In closing, the prosecutor told the jury Allen started confessing on April 3rd because he'd given himself to Jesus the day before. This excluded April 3 calls. The excluded April 3 calls tell a different story. Allen was losing his mind, showing lapses in memory, and confusing dreams with reality. The prosecutor got to offer an inculpatory story for how the confession started, while Allen was prohibited from presenting an exculpatory story through contemporaneous evidence. The trial court erred by excluding the statements and behaviors that proved the foundation for Dr. Gracian's opinion that Allen's confessions were not credible. Yeah, I mean, that makes sense, Alan. I mean, it doesn't, but it does. Like, if there's an argument you're going to make, it would be that. I think that's silly, but... At trial, Dr. Gracian testified that Allen suffered from delirium, but the judge prohibited Gracian from discussing the statements that provided the foundation for this opinion, including Allen's statements that were patently false. This was reversible error. First, Allen's false statements were not hearsay. He offered the statements to show his state of mind and prove that he was saying things unworthy of belief. True. Second, even if hearsay, the statements were admissible under 703. Yes. Third, the statements were admissible because the state opened the door 3 times. Harshman testified that Allen's confessions were consistent with the facts and included details only the killer would know. The state also paraded witnesses before the jury who opined that Allen's mind was intact when he confessed. He was faking his symptoms, and Dr. Walla testified she saw no reason to screen Allen for delirium. Allen was entitled to counter all this evidence that his statements were false, inconsistent with the murder scene, inconsistent with delirium. Independently, this error was harmful and warrants reversal. In closing, the prosecutor molded the story that despite Allen's undisputed psychosis, his confessions were truthful. The judge affected the jury's decision when she prohibited Allen from showing that he made repeated untruthful confessions. All right, one bit of quick analysis. I'm trying to like the stream, not the outcome. Anytime you can point to the prosecutor using something in argument, it's helpful because it shows the importance of the evidence in question. That's kind of intuitive, but one thing I noticed. Together, the above 3 errors violated the Constitution. The Constitution prohibits the court from stripping a defendant of the power to describe to the jury the circumstances that prompted his confession. That is precisely what happened here. Allen repeatedly presented evidence that placed his confessions into context and impeached their credibility, but the judge arbitrarily excluded the evidence and disproportionately ruled in the state's favor. Let me see. Reversible error in denying Allen's motion to correct. Allen timely filed a motion to correct, arguing the state elicited false testimony and allowed it to go uncorrected. The trial court denied the motion. The 14th Amendment is violated when the prosecution knowingly solicits false testimony or knowingly allows it to go uncorrected. Yeah, this was a recent case earlier this year. Napoli is the older case. According to Dr. Walla, Allen confessed that he was attempting to rape the girls, but abandoned his efforts and fled with them across the creek when he saw a van. At trial, the state elicited testimony from Brad Weber, who told the jury he left work at the Subaru factory in Lafayette, Indiana, around 2:02, and drove his white cargo van directly home. The prosecutor told the jury that the timeline for Weber's testimony, Allen's confession, and the step data on the phone matched perfectly and proved Allen guilty. Take a look at the health app data. There's a pause and then moving for 7 minutes. He has 7 minutes with them, but before he can finish the deed, he sees a van. Brad Weber's coming home from work down his private drive to his home, and he scares Richard Allen. Allen forces the girls across the creek to a spot in the woods, a secluded spot, and he kills them and he cuts their neck. Weber's testimony was false, and the state knew it. Yeah, again, they're just tying it into the argument for emphasize the importance of the error. Specifically, security camera footage from Weber's neighbor showed him arriving home around 2:44. And an FBI report showed Weber's cell phone arriving home around 2:50. The error was constitutional and requires reversal. A Napoli-Glossop error requires reversal if it could have contributed to the verdict. Again, prosecutors in closing, so it's really hard to argue that it did not. Here, the false evidence, if corrected, would have shown that Weber's arrival home was inconsistent with that state's murder timeline. He arrived home 25 minutes after the pause and movement on LG's phone, and nearly 15 minutes after LG's phone was on the other side of the creek and hundreds of yards away from Weber's home. Thus, Allen's statement to Waller are inconsistent with the truth and suggest he was delirious. Error requires reversal. The trial court committed reversible error when it excluded Allen's evidence explaining this murder as a ritual killing. This was reversible error. Evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime, and thus meets the definition of relevance. Here, Allen tendered Don Perlmutter, a recognized expert in ritualistic killings and atypical homicides, to explain the elements of ritual killings. Ritual killings commonly occur outdoors, in wooded areas, and near bodies of water. They occur on holidays significant to the group and often involve the use of ceremonial knives. There will be symbolism at the scene, and with Norse pagan rituals, the symbolism will likely involve runes, arranging natural objects in a specific way, and perhaps combining the runes with bloods. Blooding the runes, we read about this earlier. Is it precocent? Precocent? I'm going to go with precocent. Hello. You don't get bullet wounds. Rather, there is usually throat slitting, blood loss, and perhaps torture. You would expect the sacrifice to be displayed or arranged at the scene in a manner that is significant to the group. And finally, you would expect to see an atypical or symbolic blood pattern. According to Perlmutter, this murder scene included all these elements. The murders occurred outdoors in a clearing and near a creek. The murders coincided with the Nordic holiday Valisplot, which honors Odin's son Vali. The girls' throats were cut with a knife and they bled extensively. Perlmutter found the sticks to be obvious symbolism and difficult to explain in any other way. In her opinion, the stick arrangement on AW mirrored the Norse rune Giba, and the stick formation on LG looked like a Nordic bind rune. Perlmutter also explained that the bodies were arranged in a manner consistent with a pagan ritual. An upside-down hanging body is an important element of Norse paganism because Odin hung from a tree for 9 days before discovering runes. Pagan sounds like you're saying... I'm totally... my nose is stuffy, my voice is going... I probably sound messy in general. Pagan. I'm not trying to say it that way. Man, all right. Next time I'll do better. Here, the blood patterns on the girls' faces suggested a person lifted their bodies and articulated the torsos and necks around their chins. AW's leg was bent behind the other, mirroring the classic image of Odin. and the blood pattern on the tree appeared to look like a Norse pagan Fehu rune. Perlmutter had the knowledge, skill, and experience to offer this testimony. Expert testimony should be admitted if the expert is qualified by knowledge, skill, experience, training, or education, and the testimony will help the trier of fact to understand the evidence or to determine a fact in issue. Never made a docket record. Yeah, I mean, that could be right. Different places call it different things. Docket report, docket record. You're probably right. Let me see. Here, Perlmutter is an expert in ritualistic killings and a recognized federal subject matter expert on a typical homicide and ritualistic crime investigation. And she's the author of Ritualistic Crime Scene Investigation, a field guide for law enforcement officers investigating ritually motivated crimes. I can say, thank you. Still never cleaned up the docket. Yeah, I did skim through the appendix, and I know the docket was like incredibly long. I assume it's just a mess. I didn't actually read it. I did notice how long it was. And I mean, even for like a lengthy murder case, it's not usually that long. She was qualified. Let me see. Perlmutter's testimony was not conjecture. There was always a discussion. True, there was actually discussion among law enforcement that this may be ritual murder and that these sticks were Nordic runes. It is helpful that the theory didn't originate with the defense. Kind of makes it hard to disclaim. Yeah, I know Andrea was battling over the public records. I was halfway flying that on Twitter. The BAU declined to exclude pagan ritual as a plausible explanation for the murder scene. A consulting professor found it quite plausible. These stick markings constitute an instruction inspired by Norse runes. And an undercover law enforcement officer familiar with the runes also found pagan symbolism at the scene. Perlmutter's testimony would be helpful for the jury. Although motive is not an element, juries want an explanation for the crime. When motive is unclear or inconsistent with the defendant's guilt, juries are more likely to acquit. Similarly, when a murder scene is complex or unusual, it is important the jury receives an explanation. Here, the murder scene was complex and unusual, and the jury would naturally want an explanation. The sticks immediately stand out to any rational person as unusual and warranting an explanation. Perlmutter's testimony provides an answer, explains the scene, and offers a motive. Her testimony would be helpful to a jury. Excluding Perlmutter violated the Constitution. The defendant is entitled to answer the prosecution's case with his version of the facts, so the jury may decide where the truth lies. A judge cannot infringe upon this right through the arbitrary, disproportionate, or mechanistic application of the rules of evidence. Accordingly, if the state offers an inculpatory explanation for the evidence, trial courts cannot use the rules of evidence to prohibit the defendant from offering an exculpatory explanation. By excluding Perlmutter's testimony, the trial court allowed the state to offer an inculpatory explanation for the murder scene, while denying Allen his constitutional right to offer an exculpatory explanation. This arbitrarily and disproportionately denied Allen his constitutional right to present a defense. The error was not harmless. The state told the jury repeatedly this case was about a brutal murder, and it explained the evidence in a manner that incriminated Allen. The jury received a one-sided explanation for the crime, without Allen being able to counter it. The error affected Allen's substantial rights and altered the jury's decision. The trial court denied Allen's right to show the state's investigation was incomplete, overlooked plausible leads, and mishandled evidence relating to third-party guilt. The trial court prohibited Allen from presenting any evidence regarding the manner, quality, and thoroughness of the investigation into this murder as a ritual killing. A defendant is entitled to have his case proved beyond a reasonable doubt. And the accused can create doubt by showing that the investigation was incomplete, overlooked plausible leads, or that law enforcement mishandled evidence relating to a third party's guilt. Here, Allen presented evidence that the states performed an incomplete investigation, mishandled and destroyed evidence, and overlooked plausible third-party leads connected to pagan rituals. After examining the scene, several officers believed it was too complex for just one person to be involved. And the Carroll County Sheriff immediately thought the sticks related to pagan rituals. The day the girls went missing, law enforcement learned that AW was having a secret relationship with LH. That week, law enforcement interviewed Holder and his friend Westfall. Let me see. Holder reported being involved in a pagan tribe, spending every weekend at Delphi, engaging in pagan rituals with Westfall and 5 or 6 others. These rituals involved animal sacrifice and human bloodletting. Holder told police he owned a .40 cal, but officers did not examine or collect the weapon, nor did they search his phone. Holder told police he was at work at a Liberty landfill when the girls went missing. Law enforcement recorded over Holder's interview, permanently deleting it. In his interview, Westfall told law enforcement he knew the woods where the girls were murdered very well. He reported knowing the girls, but denied ever meeting them. He also reported being a religious leader for local pagans, and he wore a necklace to the interview representing his efforts to pledge the Vinlanders, a pagan social club. Law enforcement elected to record Westfall's interview, and when he asked for an alibi, Westfall claimed he was home with his minor son. In the 5.5 years between the interview and his arrest, law enforcement took no further action. After Holder's interview, tipsters repeatedly called and reported him as a person of interest, claiming he posted pictures of half-dead women with symbols out of tree branches. April 13th, I talked about this before, officers visited the landfill to investigate and spoke with an employee, Susan Case, who provided a printout showing Holder swept out of work at 2:45, which was 30 minutes after the video. Case invited the officers to review video to confirm, but they declined. His marks is cleared. Read this before. I think I read this part before, too. I read this. Winters was not satisfied. Yeah, I read all this. There's all in here before. Read this. I made a joke about this that Nick liked. Just restating the pagan evidence. I think this was all verbatim earlier in the brief. Okay, here the omitted evidence created reasonable doubt and raised questions of the utmost importance about the manner, quality, and thoroughness of the investigation that led to Allen's arrest 5.5 years after the murders. Had the jury heard it, a different result was likely. The very premise of our adversary system of justice is that partisan advocacy on both sides of a case will best promote the ultimate objective that the guilty be convicted and the innocent go free. Because the trial court prohibited the jury from hearing Allen's side of the story, showing how law enforcement went down the wrong path, justice could not be done. The appellant, Richard Allen, requests this court reverse his convictions. All right, I'm done with the brief. Now I need to do my my actual research into the case. I have 13 volumes to get through, so that's probably going to take a little while. All kinds of good stuff here. Oh, man. I think I'm going to call it a day. My throat is shot. I wish I could talk. But yeah, thanks for tuning in, for tuning in. Thanks for showing up. So many of you are new here. I appreciate that. Blame the witch. Yeah, I should. But yeah, I'm going to call it a day. Let me see if I can remember how to redirect people. SPOC. Yeah, I'll definitely check that stuff out. Ooh. Hmm. Ooh, we're going back to Cat, not Williams. I think. Yeah, we're going back to Cat. All right, I'm going to redirect. Thank you, Trey. My voice is gone. Yeah, no, I'm happy to do it. I'll do another one where I have like more insight, hopefully. But there definitely seem to be a lot of grounds for vacatur, and I'm definitely interested in what the grounds will eventually be. Yeah, definitely a lot of questions. And I'm also interested in seeing what wasn't involved in this, because it's always difficult to choose what to include in a brief and what not to. It was a spork, I believe. It was not a fork. I believe it was a spork that was stuck in the genitalia. I want to be clear about that. That makes a significant difference. All right, everybody. I'm sending you over to Cat. I'll be over there. Bye, everybody. Thanks for watching. How long does it normally take? It'll be a statute. I'm not sure. In a lot of places, it's like 20 days. Sometimes it's longer. 30 days. Justice for the spork. Why doesn't anyone think of the spork? All right, guys. I'm going to call it a day. But yeah, thanks for watching. And I'll let you guys know when the next one will be. But yeah, have a good one. I'll see you at Cat Stream. 30 days, 30 days. Okay. Damn, that's a long time. I'm sure they won't wait till the last minute. I guess. Bye, everybody.